Sir, online and offline advocates, please maintain 2 minutes silence at 11 a.m. sir. ಇಲ್ಲ ಸೈಲೆನ್ಸ್ ಅಷ್ಟೇ ಸರ್ 11 ನಿಮಿಷ ಕಾಶ್ಮೀರ್ ಇದಕ್ಕೆ ಏನ್ ಸರ್ ಕರಿತೀವಿ ಅಲ್ಲ ಕರಿತೀವಿ ಸರ್ ಕರೆದಾಗ ಹೇಳಿ ನಾನು ಹೇಳಿದ್ದು 11 ಗಂಟೆಗೆ ಸೈಲೆನ್ಸ್ ಮೇಂಟೈನ್ ಮಾಡಬೇಕು 11 ಗಂಟೆಗೆ 2 ನಿಮಿಷ ಸೈಲೆನ್ಸ್ ಪೆಹಲ್ಗಾಮ್ ಇದಕ್ಕೆ ಸರ್ ಇದು ನೋಟಿಫಿಕೇಶನ್ ಬಂದಿದೆ ಬರ್ತಾರೆ ಸರ್ ವೆರಿಫೈಯಿಂಗ್ ಅಫಿಡವಿಟ್ ಬಿಡಬೇಕು ವೆರಿಫೈಯಿಂಗ್ ಅಫಿಡವಿಟ್ ಅದ್ರ ಜೊತೆ ಬರಬೇಕು ಅಂತ ಅಫಿಡವಿಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಜೊತೆ ಅಫಿಡವಿಟ್ ಇಲ್ಲ ಅಂತ ಸೈರನ್ ಬರುತ್ತೆ ಅಂದ್ರು ಕರೆಕ್ಟ್ ನಾನೇ ಕೇಳಿದೆ ಫಸ್ಟ್ ನಾನು ಅಂತ ಫಸ್ಟ್ ಪರ್ಸನ್ ಸೈರನ್ ಆಗ್ತೀರಾ ಇಲ್ಲ ಇಲ್ಲಾಂದ್ರೆ ಇಲ್ಲಿ ನಡೀತಾ ಇರುತ್ತೆ ಸರ್ ನಾವು ಹಿಂಗೆ ಸುಮ್ಮನೆ ಎಲ್ಲೂ ಇಟ್ಟಿದ್ದೀನಿ ಬಟ್ ಸ್ಟಿಲ್ ಸೈರನ್ ಬಂದ್ರೆ ಎಲ್ಲರೂ ಇದಾಗ್ಬಿಡ್ತಾರೆ ಶೆಕೆಗೆ ಅರ್ಧ ಸುಸ್ತಾಗುತ್ತೆ ಕಬಡ್ಡಿ ಸುಸ್ತು ಅನ್ಸುತ್ತೆ ಬೆವರು ಹಂಗೆ ಬೆವರು ಬರ್ತಾ ಇರುತ್ತೆ ನಿಮಿಷ ಬರ್ತದೆ ಓದಂಗಿಲ್ಲ ಇನ್ನೊಂದ್ಸಲ ಅನೌನ್ಸ್ ಮಾಡ್ತೀನಿ ಸೈರನ್ ಬರುತ್ತಂತೆ ನಾನು ಕೇಳಿದ್ದಕ್ಕೆ ಒಂದ್ಸಲ ಲೈವ್ ಇದೆ ಸರ್ ಲೈವ್ ಇದೆ ಸಿಕ್ಕಿದ್ರ ಕೊನೆಗೆ ರಾಘವೇಂದ್ರ ಅವರು ಮೇಡಮ್ ಹೊರಟಿರ್ತಾರಲ್ಲ ಇಲ್ಲ ನೋಡಿ ಗೊತ್ತಾಗುತ್ತೆ. Sir, once again, I request all the advocates to maintain silence for 2 minutes at 11 a.m. Sir.
You can see online only. You can see online.
What is the urgency? When was the execution? The date in execution? Objections clear? Where, before which authority? Before which authority? Why, what is the urgency? That's application for withdrawal. You inform the other side. You notify the date also. Just 1 minute,
Sir.
Mr. Gujja, take it.
Sir, 30th holiday, sir. 30th holiday ಇದೆ.
30th, we will have tomorrow. See?
Execution. We have 5 objections and also on 9th the memo was moved. It wasn't posted.
Right, the memo was moved?
Yes.
What happened?
It was not listed.
What was the date given?
Date was not given.
That's the reason it was not listed. So what is the urgency today?
Your Lordship, interim order has been granted.
So we'll have it after vacation. Not possible.
Medical expenses.
No, what is the medical reason?
Lordship, he has been admitted.
So how will this vacation will help him?
The Lordship, the amount has been
We have filed an application for withdrawal.
not withdrawn.
Then
Execution proceeding has been stayed. That's why we have filed
okay, have it tomorrow.
Opposite side ಇದೆ.
One will come back.
Opposite
Any
side
other
ಇದೆ.
mentioning?
ಯಾರು ಅಪ್ಲೈ ಆಗಿಲ್ಲ ಅಂತ. Sir, total 3. Sir. Sir.
Both all 3 men.
Sir, total 4 ಇದೆ.
No, it's not before us. We have to mention it before
Opposite
end
ಯಾರು
up.
ಇದೆ?
Not before us. Okay.
ಇದು ನಾಳೆ.
Which number?
Memo, my lord.
Yes.
My lord, respondent has filed execution petition before Honorable District Court, my lord. Even I have moved the early hearing application also, my lord. Kindly have it on tomorrow, my lord.
When is the execution?
My lord, 24/6/2025, my lord.
When is the execution?
24/6/2025, my lord.
We have time. We mention it after vacation.
Please.
We go urgency.
For adjournments, page number 8, 26, page number 9.
My lord, serial number 28, appearing for petitioner, my lord. Any date after vacation.
Serial number 26, ma'am. Any date after vacation.
Yes.
Serial number 28, my lord.
Just ask her to wait. We will call the matter.
Madam, 1 minute, madam.
Lordship,
Wait 1 minute.
serial number 29.
Serial number 26,
please.
ma'am.
One at a time.
Serial number 26, my lords.
Yes.
26
Which
and
page?
26.1 to 26.5.
Yes.
26 I'm the appellant, 26.1 to
Who is the
0.5.
other side?
The other
Have
side.
you- have you told
I've
them?
informed them, my lords.
You have informed
I've
them?
informed them.
You will or have?
I have, ma'am. I have.
At the request of counsel for?
Appellant, my lords. For the first
You
matter.
are appearing for whom?
For the appellant, my lords, 26 I'm the appellant,
You have informed
26.1 to
Mr.
0.5.
Deshpande?
No, my lords, Swarup Anand. I'm for Mr. R. Swarup Anand.
No, but you have informed Mr. Deshpande?
Yes, my lords, I have informed.
At the request of counsel for the appellant in MSA 58 of 2018 and the respondents in the connected appeals seeking an adjournment stating that he has informed Mr. Madhukar Deshpande appearing for the opposite side, comma, re-notify on.
30th July,
Much obliged, my lords.
page number 9, 27 to 31.
My lord, 28.
Serious,
Which number?
27.
27, tell us.
Appealing for appellant, my lord. I will inform the other side counsel also, my lord. Kindly I will tell.
At the request of counsel for the appellant.
27.
Seat
27.
call ಮಾಡ್ತೀನಿ.
At the request of counsel for the appellant stating he has informed the other side for an adjournment adjourned to.
30th July,
My lord, 28, serial number 28, I'm appealing for.
Yes, ma'am, tell us 20. What do you want? Yes, can you hear us?
Yes, my lord, serial number 28, kindly have it on after vacation, any date, my
You are
lord.
appearing for whom?
For petitioner, my lord.
For the appellant.
Yes, my
Have you
lord.
informed the other side?
I'm for the respondent, my lords. Lords, my lord, I have two
No, my-
submissions. Lord, there are parallel proceedings for, my lord, regarding check bonds which are going on. There is an order of conviction in the check bond, my lord, I have been convicted, against which an appeal is filed. The appellate court, my lord, is hesitating to go on because of the dependency of this appeal. My lord, the appellate court is awaiting the judgment in this commercial appeal.
What do you have to
Well,
say on her request?
My lord,
May I
actually,
request the trial court records may be called, my lord, and it may be listed and heard.
Which trial court records?
The commercial.
Where
court,
the appeal has been filed?
Commercial court.
That's right.
In this-
That's right. So at the request of counsel for the appellant, which is not opposed, adjourn to.
30th July,
The
Much obliged.
paper, just say that the trial court record be requisitioned before the next date of hearing.
Your lordship,
Who appears for R2 otherwise?
R2 is placed ex parte. R2 is placed ex parte.
Yeah,
Served through paper publication. R2 is served through paper publication.
that's right.
your lordship, serial number 29, your lordship.
29.
Kindly may have it after vacations, your lordship.
Who is the other side?
Appellant, I have informed the other side.
At the request of counsel for the appellant stating that he has informed the counsel for the respondent for an adjournment, re-notify on.
30th July,
Much obliged.
page number 10, 32 to 34. Page number 12, 11, 35 to 38. Page number 12, 43 to 45.
My lordship, 45, my lordship. I have informed other side, my lordship. I am appellant, my lordship.
At the request of counsel for the appellant stating that he has, you said 45.
Yeah, 45, one, my lordship.
Request for
Both.
the appellant stating that he has informed the counsel for the respondents adjourned to.
30th July,
My lord, serial number. My learned friend was,
Yes,
Serial number 8, have to file the verifying affidavit. Party signed, respondent signed the office objection.
what do you want?
Office raised the affidavit has to file. So kindly in this,
You appear for
no,
appellant?
my lord, I was mentioning other matter.
You are appearing for whom?
I am for respondent, your lord.
Who is for the appellant?
Applying to Sridhar.
Just wait for a minute. We'll call the matter. Just wait.
My lord, serial number 43, I'm for the appellant. There's an inconvenience today, my lords, it may be had after the vacation.
I am for the,
I've informed my learned friend.
only one request, ma'am. I have no objection for grant
It's
of adjournment.
43.
43.
Yes, only thing is this, my lord. Can I request for the second week of June, my lord?
We will give you date. That leave it on
The
us.
difficulty is this, my lord. I'll
Yeah,
explain,
tell
my lord. Just a minute. An award passed in 2017, directing them to pay me 3 crores with interest. There is no stay order. On the execution side, I'm not able to proceed because they say
We'll
I'm
give
not
you-
an entity, therefore you
At the
can't.
request of counsel for the appellant,
About 6
re-notify.
crores of rupees is due today, ma'am.
Give it second week of June.
11/6,
Grateful, ma'am. Grateful to your lordships.
page number 15. Serial number 1. Serial number 1, Sheila, please.
Permitted to withdraw. I may be permitted to withdraw.
What happened? He has come back.
So he had arrested in some case flood and produced.
The learned counsel for the appellant has filed a memo. Petitioner has filed a memo seeking withdrawal of the petition. The same reads as under, the petition is dismissed as withdrawn.
Serial number 2.
The same is taken on record also, say. The memo taken on record.
Lords, in this
Number
matter,
two.
therefore, the petitioner, my lords, in the last date, my lords, they file a status report, my lords, which is nothing but a replicate of the status report filed in the earlier writ of habeas corpus.
Right, but just show us the file, ma'am. Status report.
She was traced 2 times earlier. Lord, earlier writ petition, Lord, at page numbers 89, it is said that she had eloped twice and we secured her twice. Is in the habit. However, the court said that the investigation go on, and she has even filed a 498 case against him. And
My lords, there is no 498 case pending, my lords. There's no matrimonial issue, my lords. In fact, I myself filed a complaint. My lords, my lords, what happens is she's a mentally challenged patient, my lords. She's undergoing treatment, due to which there are certain instances where she goes missing from the house, my lords, but she comes back within 3 days, my lords. In this particular incident, what happens is she is taken from the hospital to the Vivek Nagar police station, my lords. After being taken to the Vivek Nagar police station, she goes missing. Please, my lords, it's not. Please, my lords. My lords, they've not taken any action since 2023. My lords, to trace out the wife, my lords. My lords, the last petition was disposed of on 4th of September 2023, my lords. In the status report, there's no. Please, my lords. Only a requisition was. Please, my lords. Only a requisition was sent out to the DCP's office.
True, my lord.
You should not just rely
Yes.
on the earlier one. Because that liberty was there, court had given.
Yes. Lord, see the earlier paragraph, Lord. Paragraph
Just
2.
see that earlier order.
Paragraph 2 at page 90, my lord. Commencing from page 89.
Yes.
Paragraph 2, my lord. Your lordship gets it.
So what is the conclusion in the investigation of 110?
Lord, conclusion, we will have to take it to the logical conclusion only on finding her. My lord, missing is not an offense at all under the law. Even habeas corpus would not be maintainable. But we will conclude the investigation.
It is not a case of an illegal detention or a.
Nothing. Even not an offense, yes. She volunteers to go.
Possible.
Yes,
Possible. Because the earlier past precedent says she had gone herself.
she has eloped with somebody who died.
But FIR 110 is there.
Yes, it is there. We will, yes.
So you must have taken that FIR to some investigation after that September matter was disposed of.
Yes.
So if that liberty is there, based on the result of the investigation in 110,
Yes,
you must know, at least he must know what further investigation you had carried out.
yes.
So the final statement.
Yes, one more status report.
My lords, may I point out one aspect? My lords. In page number 4 of the status report, my lords, they themselves say that on 4/7 she had appeared before the police station, my lords, which is where I was illegally detained and she was taken with the head constable, my lords, which is after.
When was that?
Status report, my lords, on 4/7.
Status report.
The status report filed on the last date, my lords. Page number 4, paragraph 15, my lords.
That is prior to the disposal of the writ petition.
That's prior to the disposal of the.
Please, my lords, my entire allegation is that on 4/7/23 itself she goes missing. Please, my lords.
That observation.
Please, my lords.
what further investigation they have done, we want that status report to be done.
Please.
Okay.
Yes, no. If your lordship looks at paras.
What is this line number 34 of 22?
My lord, she had complained about cruelty, 498.
That charge sheet is pending.
No, we registered a non-cognizable report and closed it. Closed it, which means
Nothing on his part.
nothing on his part, but which means she is not willing to stay with him.
My lords, crime number,
Yes, yes, yes.
my lords, crime number 34 is a complaint filed by me, my lords. By me, my lords. It's available at page number 31.
Sorry.
My lords, against the person who has committed suicide, who she alleges to have eloped with, my lords. My lords, charge sheet is filed and case is pending trial, my lords.
As against the man who committed suicide, that is that. That gentleman is no more. That she had eloped with him earlier. So that has no bearing or relevance to this.
State, it's not our intention that we want to page 95 of the paper book to contend that in terms of the liberty granted by this court, the earlier petition, the petition 82 of 2002, the earlier petition being 82 of the WTHC of number 82 of 2023. No further investigation has been undertaken by the state, as is clear from the status report. Mr. Villiyappa, though, draws our attention to paragraph 3 of the status report. He states that the further status report shall be filed.
Yes.
15D, highlighting the further investigation carried out in FIR number 110
Of 23.
23.
Okay, within 4 weeks.
Yes.
This
Great.
26-6. Serial number 3, Shri Sudhindra.
Petitioners on this matter, lords. Petitioner's father was missing.
Not. The lords grant some more time. We will file another. One is filed, one status report is filed. This is a case where a man aged about 69 who has lost his memory to a little extent. We will.
Yes, ma'am. On 31/12/2024.
Looks. The first time he's missing, my lords. It's not it. True, my lords. True, my lords.
Let's keep this.
Please, my lords. Let's even be. Yes.
Get those that remedy. I think that would be appropriate. Otherwise, this could be, you don't know where will this petition of this nature when a person is missing, given the fact you don't want to say anything on that. So, how much forward we can go with this petition?
Only draws.
Any remedy, you must look into that. Other than, pursuing this, that's what our view is.
So only the state is empowered with so many things, my lord, so that they can help us out. As a common man, I don't have any.
Right. And so far, have you filed a status report?
Yes, yes.
You have filed a status report?
CH-2.
We will furnish one more, Lord, and we'll also file on the next date of hearing if need arises.
Yes, sister. Let's see your status report. Keep it popular.
Yes.
See, they have given in senior term. Starting from 1/1/25. And if you see that these are all steps which they have taken.
True, my lords. They have.
And quite
No grouses against the prosecution.
right. We are only,
Trying to help us. We are just requesting to them to help us out, if at all. At least a logical end, whether he is alive or he is no more. At least to that extent, my lords.
see, given the steps which they have taken,
Please, my lords.
to the extent possible within their
Vicinity.
capacity or the power. And they have not able to find him. Any other steps which you can take where you can, in this country with this population, everything,
Yes.
that may be.
Lord, in this, elaborate steps have been taken, my Lord. When they have visited old age homes, brothel place, beggary colony, paper publications, all these have been done. Considering his age and that
The gentleman has some issue with the
memory.
memory.
A bit age related, my lords. He was working as a coolie in a coffee estate. Subsequently, he was migrated to Bangalore with his son's place. Later, my lords, he's been missing on 31/12/2024. There was no reason, there was no quarrel, nothing of that sort. Please, my lords, please. Please, my lords.
Something good is done.
Yes.
Otherwise, you must think over.
Please, my lords.
So do you coordinate with the neighboring states also?
Yes, sir.
But that is not something which has been said here. You said so.
Lord, we have done that also, my Lord. Post this, we have done that, my Lord. We will file our. Yes.
Possibly you can tell them.
Yes.
Neighboring state, because like going, if you can, what would be the distance here and Tamil Nadu border?
Yeah, but when a missing person has a history of connections with the other states, we do that. This man is from Chikmagalur and within the district and the state. So therefore, that step is not taken. We will do that also. If he's a Tamilian or a Teluguite, we do that.
States that further investigation shall be carried out and the status report shall be within 4 weeks or within 6 weeks.
Yes.
Obliged.
26/6. Serial number 4.
My lord, I hear for the petitioner. WPHC pertaining to preventive detention, my lord.
Lord, we have filed our objections. We will secure the records. Could the lordship from the advisory board? The records will have. We will file during the course of the and secure the records. We will file during the course in the registry. Yes, we'll get the records.
My lord, may I request for a date before vacation because he's been incarcerated from 29th of January 25. That's the only request if your lordships can accommodate that. I'm ready to address arguments.
First week of June, my lord.
Because he'll
On the reopening day.
He'll be incarcerated for 1 month, my lord. That's the, and they were given 3 weeks time on 24th of March to file their objections. Yes, my lord.
The records are not there. And
yes, they have served, my lord. I'm ready. And I have the records that the Detention was furnished in 3 volumes. I can make it available to court. Not the one with the advisory board, but the other 3 volumes which is furnished.
from the advisory board. Or, my lord, second, my lord.
Very well.
Yes. Yes.
Very well, my lord.
Yes.
Very well, my lord. I'll make that available. They are furnished, my lord. They are furnished. Grateful.
Serial number 5. Shiva Prakash.
The office objections that are not filed this objection filed by the opponent. The matter was heard here in Bangalore bench, my lord. Then matter has been transferred to Gulbarga bench, where judgment is pronounced. I am told that there is no objection filed by the 555 writ appeal. In the it's a connected matters. May I kindly take my lord to page number 19. Now I am told that the government has also filed an appeal. Government appeal is 883 of 2024.
Please, my lord. My lord, I don't know.
There is no date because there are also several objections. Number is given as 883 of 2024.
No, my lord, notice has not gone. Please, my lord, there are certain objections in it, so. Please, my lord. Yes. Please.
That's correct. My lord, and this pronouncement of judgment is from Gulbarga bench. Though it was heard here in Bangalore, then at the time. Yes, yes. When it is Bangalore bench. What happened is when the matter was taken up for final disposal there, one of the respondent has filed objection, but that copy is not served on us. That's the issue. There in Gulbarga. Please, my lord. So that now government appeal 883 of 24, if it is clubbed together, so that we can resolve the issues.
You are for the original petitioner.
Correct.
Yes.
They say that solicitor appears for the state. You appear for 1, 2, 3.
1, 2, 3, my lord.
That even the respondents have also filed appeal against the 2.
First of March 2024.
In which petition you have filed appeal? There are 4 petitions.
9861 of 2017.
861 of 2017. She states that the same is lying in objections. Do you think this is sufficient or given the appeal? Mr. Prakash, the office objection as notified by.
Please, their government appeal is 883 of 2024.
This appeal number 883 of 2024. The petition number 9861.
Correct, ma'am.
Yes.
Oh, bless. in the,
Oh, that's 23/6, we have a date also.
23/6.
So we'll have it on there.
On the same date, can.
Seal number 6. Seal number 6.
So for them to comply with the amendment,
You want to carry out with the this.
they haven't done it in the previous
Who
day.
was, you are for the respondent number 1.
Yes, no, give it. Only
Who was the appellant?
they haven't appeared even in the last day, and also they are not proceeding with the execution matter in a trial court manner. In fact, the appellants here, there is an execution, and they are not even accepting notice in that case.
Where filed the execution?
Yes, no.
Did they appear there?
No, they haven't accepted even the notice.
Then after notice,
Yes, no.
just wait, pass it.
My humble submission, the last time we will be going for amendment, next week we can close the bill.
Just wait, possibly pass it.
7, Shri Prakash Angadi. Serial number 7.
Lord, I appear for appellant, my lord. Kindly pass over the matter, my lord.
Serial number 8.
Yes, serial number 8.
Yes.
Move for responding. So I had a amount paid to the appellant 22 lakhs. And another one co-owner had taken 95 lakhs 50,000. And one of the co-partner paid all the amount, but the appellant has not paid the amount and filed the suit before commercial court. Commercial court, he was not appeared and not filed the WS. And
You have filed the suit.
So actually stayed. Amount is deposited in the court, has to be released. And without agreement, without question, negotiated. Amount to be released.
Have they deposited the
Commercial court is not appeared and is ex parte, is delaying tax, he was not appeared. Without any agreement, we had paid. And he has given commercial space to third parties. And even we have given 3 notices, he is not replied at all.
There is already an order for withdrawal.
So, madam, so bail point.
There is.
Amount to be released.
There is already an order for withdrawal.
Order of withdrawal, order of.
There is already an order.
ಆರ್ಡರ್ ರಿಕಲ್ ಇಲ್ಲ ಡಿಪಾಸಿಟ್ ಆಗಿದೆ ಸ್ಟೇ ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲ 50% ಕೊಟ್ಟಿದ್ದಾರೆ ರಿಮೈನಿಂಗ್ 50% ರಿಮೈನಿಂಗ್ 50% ಅಮೌಂಟ್ ಟು ಬಿ ರಿಲೀಸ್ಡ್ 16 lakh 40,000 50% ಕೊಟ್ಟಾಗಿದೆ
Just asking, has he withdrawn the 50%?
Withdrawn the 50%, he wants the
remaining for 16 lakhs for 20,000 for 30. Without any agreement, without question, is delaying tactics and promised.
We'll just pass over.
Pass over.
Pass over.
Serial number 9. Shri Sachin.
Yes, Mr. Sachin.
My lords has heard this matter for some time last occasion. Just to refresh my lord's memory, lords, this is a case of TDR. Good.
You appear for who?
BBMP.
Friday is the last day, my lords. And BBMP is only a form. Direction is to BDA. Every time BBMP, my lords. Huh?
At the request of the council for BBMP. That we have asked for. Your appeal was dismissed. Friday.
2-5.
230 days.
Serial number 10.
Interim order be extended. my lords.
Yes, Friday.
Interim order be extended.
Interim order if any.
Great.
Serial number 10. Yanu Bharatwaj.
Please, madam. There are two memos. One is 8/12/24, other is 9/12. Complaints is reported. My lord was treated to this memo last time, and it was orally accepted, but the office still repeats the objection. So the original petitioner number 1 passed away during the pendency of the writ petition. His LRs are already on record. This was noticed by your lordship. Then we have filed a memo on 9/12 to say that they are already on record, no need to bring the LR. That may be accepted. Number 1. 2 is on 8/12 we have filed a memo showing the deposit of 5,000 awarded to Advocates Welfare Fund. On same date, 9/12. That also is complied with. Today they have raised an objection that death certificate should be produced. We are producing that also. Raising objection in installments may have to be stopped. Both of them are dated 9/12.
Yes. So petitioner number 1 had expired.
Yeah, it's blood. Sadashiva expired during the pendency of the petition. His LRs are on record. They are the members.
Who are the LRs?
The rest of the petitioners, rest of the appellants.
Gangama and
Gangama and others. Now Gangama is dead. We are filing the death certificate of Gangama. They are the other LRs are there.
Gangama has also expired.
Also expired. Death certificate they want. We have produced a certificate today. Oh, sorry.
That death certificate is not of.
No, Sadashiva. I was corrected back. Sadashiva.
What about their LR? Gangama's LR?
Gangama's LRs are the sons and children. They are the other parties.
They are here.
Yes, they are already on record. Death certificate of Gangama is also filed on 24/1.
But who are the Gangama's relatives?
That is 2, 3, 2, 3 and others. Up to 6.
2, 3,
Oh, up to 6.
they are all the children of Gangama.
They're all the children of Gangama.
And what about Gangama? Gangama is to the wife of Sadasivaya.
Sadashiva. This has been explained number of times. Office. And for 2 years, this is pending same thing. The other objection is payment of 5,000 rupees cost. That's also reported. And yes, my lord, deposited and receipt is also produced on 9/12. For immediate reference, I'm giving the office copy here.
They say that the senior counsel has filed before the court the memo fixing their will. That's a certificate in respect of Sadasivaya. The petition number 1 is the petition 5074. We have also seen the memo filed by the appellant on 9/12/24, which reads as under said memo is primarily related to primarily reporting the death of petitioner number 1.
Sadashiva.
Petitioner number 1, petition 25074 of 2022. Sadasivaya. We have been informed by, have you filed any
Memo. Gangama, that also reported.
memo in respect of Gangama?
They also, same similar memo is filed, that's also has to be accepted. 23/1/2024. Kindly pass it on, kindly pass it.
It must be on record.
It's on record. I have got the seal here. 23/1. Filed on 24/1. ಇದು ಕೊಡಮ್ಮ ಇದೆಯಾ
Where is that memo regarding Gangama?
20, permit me. It's on record. Seal. 24/1. 2020. I'll permit me to make it available to the Honorable Court, the seal.
Mr. Shankar has also drawn our attention to memo dated, memo filed on 24/1/24, which reads as a the said memo is reporting the death of the first appellant, namely Srimati Gangama. So Shankar reiterates the contents of the memo to submit that the legal representative, the elders of deceased appellant number 1 are already on record. It clarifies his submission by stating that the appellant number 2 to 6, appellants number 2 to 6 are the legal representatives of the appellant, late appellant number 1, That's right.
Please. Then 5,000 rupees also may be recorded. 5,000 we have paid. Otherwise, the office will raise that objection again.
Where is the receipt, Mr. Ashok?
5,000 rupees receipt.
He has also drawn our attention to a memo filed on 9/12/24 to state that the cost of rupees 5,000 has been audited with the welfare fund.
Advocates Welfare Fund.
Advocate welfare fund.
All of his objections are removed.
That we saw necessary corrections we made in the memo of parties. Amended memo of parties shall also be filed. Now it would be
According to me, Sadashiva dead by. Dead by.
Gangama by Elas.
Yes, that's how. I mean, some do not follow the procedure. Shall we correct it likewise, Pilat, so that record will be right straight?
Objections as identified by the DC in respect of such an applications, we also be clear before the next date of hearing. List of
There is one more objection. We have brought to the notice of the court by way of information that when we asked for records, they said we don't have records. That information, not office calls it an additional document. They are not additional document. No, we are not filing additional document. Additional information to say that they say we don't have records.
No, but if we find there is an application where you have brought out certain documents.
No, application is not filed. We are using it at the time of admission. Tomorrow, if it can be listed, I'll be happy. Otherwise, first of all, the reopening day. 2023 matter.
These are the documents, Mr. Shankar.
That they're all right under the obtained under the Right to Information Act.
That's right. But there are certain documents, but you will not deal with that now.
I think so. To be considered later.
Yes.
Could it be listed tomorrow if it is possible?
For what?
Admission. 2023 matter.
We want that amended memo must come on the office. Without that, we will not take it further. But that will be the basis for us to issue notice.
Relist and.
You tell us. Let's have it in first.
Please. Amended.
5-6. 5-6. Serial number 11. 11.
Yes, my lord, I appear for respondents, my lord. 1 and 3, my lord. Application has been served. I will be permitted to file objections, my lord, to that application. Several office objections in several IAs which has been filed by the appellants.
What is the date?
Yes.
May I please, court? I appear for the appellant. May I request the court to kindly peruse the order dated 23/8/2024.
Yes.
Court may kindly recollect the matter was extensively heard, and thereafter this interim order came to be passed, and a direction was issued directing them to file statement of objections to my prayers in the writ appeal as well as the interim application. Till this day, no objections are filed.
Yes.
They want to replace we have been working from 2016 as guest faculty in the Respondent Institute. We have no objection for them to make a direct recruitment. They don't want to make it. They just want to replace one set of temporary lecturers by another set of teachers. This matter was heard at length.
Lord, objections, my lord, I would file, my lord. I not file. I seek time, my lord. Lord, 2 weeks time, my lord, I will just file. My lord, the interim order, my lord, till the academic year, my lord, this like 24-25, my lord, they were continued. With my lord, in fact, I also said, my lord, they could be continued. Now, my lord, for next academic year, my lord, would commence, my lord, only in the July. So in July, my lord. My lord, so my lord, I'll file objection. Matter, my lord, needs to be heard because they were appointed only for 5 years, my lord, initially, the contract period. Then the writ petition was dismissed. Then, my lord, after a lapse of 8 or 9 months, my lord, the interim order was granted. And, my lord, they are continued now, my lord. So it's only your academic year, my lord. Guest faculty will be appointed every academic year, my lord. There, it's not a permanent post. Based on the workload, my lord, they would be appointed in each subject. Here, my lord, there were 21 candidates were there. Out of 21, my lord, only 12, my lord, are reported. Others, they have not reported. Out of that, one has resigned, my lord. So now only 11 are working, my lord, now in that college, my lord. So my submission is, my lord, it may kindly be taken immediately after vacation, my lord, on the main merit. Yes, my lord, I'll find my contact in the meantime.
In the interregnum, our service may be protected. We have no other source of employment. Interim order, that academic year will come to an end during vacation. Yes. This interim order was limited to the academic year because the learned May. Middle of May.
Yes, my lord, it's coming to end of May, but next academic year, my lord, it will commence only in July. Yes. Yes, my lord. They would be relieved immediately after the academic year. Then again, my lord, once the academic year commences next academic year, depending on the workload, they will be reappointed. It's like that. They would be relieved. Yes, my lord. Yes, my lord. Yes, my lord. It's only guest faculty, depending on workload, my lord, they would be appointed. Yes, yes, my lord. Yes. Yes, my lord. Yes, my lord.
So far as they are concerned, they are working today.
Yes, my lord. Up to 19th. 19th of May, my lord, academic year comes to an end.
How many are working?
My lord, 11, my lord. That's what I made.
Is the fact that 11 are working?
Yes, I do not dispute that. Only for 11 people, the interim protection may kindly be.
You will also agree with him that it will be till such time the academic year continues.
What was happening was, it is true that we would be relieved, but we would be given the examination duty and other related work. Even that will be stopped if we are relieved. I therefore respectfully submit.
Are you saying that guest faculties are given the examination?
Every, in fact, whatever the regular faculty handles, in fact, we
My lord, that, my lord, it's for the university administration to decide whether to give them or not, my lord. I do not know, my lord. Because yes, yes, my lord.
But surely, clearly because they have been relieved, would not mean that you will not entrust any examination work if the university deem it appropriate.
Yes, my lord. That could be.
And they shall not make any.
So what we are looking at is from May 19, it is coming to an end.
Yes.
From May to whenever we.
Next academic year. Yes.
But surely till May 19, they are continuing.
Yes, ma'am.
And they shall not make any new appointments in place of.
No, that will not, because we cannot make it because there is no sanctioned post and there is a lot of problem, my lord, for permanent appointment. Even for guest faculty, my lord, we will invite an application, then only, my lord, we will appoint. That stage has not come now.
A similar submission was made
for next
resulting in
academic
the
year.
dismissal of the writ petition.
Yes, my lord. No, not. Yes, ma'am. Respondents 1 and 3. Reopening day, my lord, before reopening day. Yes, my lord.
He also informs that out of all the appellants, only 11 have joined the duties as guest faculty.
Yes. 12 have joined, one has resigned.
12 had joined, and out of whom one guest faculty has resigned.
Yes.
Appellant has resigned.
Yes.
So today, as guest faculty.
Yes.
He also states that as the academic year is coming to an end on 19th of May 2025, these 11 appellants shall be relieved of their duties. It also states that if there is a requirement of the appellants for undertaking the examination process,
Any academic work.
Examination work, that's what it is.
any academic work, the university shall consider the appellants also if deemed appropriate. If deemed appropriate and in exigencies.
Yes, ma'am.
Okay, good. He also states that the next academic sessions shall start on.
The date, the calendar of events has not been issued. Maybe July, my lord.
In the month of
July, yes.
25. That is so, granting 2 weeks time to the appellants to file rejoinder affidavit, be notified around 19th or 20th of June.
19th June.
Much of.
Till such time, the interim, so we take on it, so we have taken your record, your submission. So we reiterate the submission made by the council for the respondents that
Up to 19th.
The services of the 11 appellants as guest faculty shall be continued till 19th of May 2025.
The lordship may say on instructions, my lord.
On instruction.
Yes.
Seriously.
Because tomorrow they should not say.
On instructions, my learned friend had made a submission that in environmental science, there is no
Solid, that,
now, contrary to that submission, they have appointed 3 persons junior to the appellants. Anyway, I'm yet to place it on record.
1 and 3, university, my lord. 1 and 3 also, college.
3 is a constituent college.
Yes. Yes, Uraja College also.
Uraja College is.
Yes. 1 and 3, my lord, for both university as well as
2 state, it's 2. Please.
much of.
Please.
Serial number 12, Srimati Sudha.
For the appellate in this case, I pray for short accommodation, my lord. We have to file our submission, written submission. Kindly have this one after vacation. Please.
You are appearing, you are in fact,
Please, my lord, for the
Only the state of Karnataka is the party.
you have filed it, ma'am? You have also
Fine, but mine is regular.
to file written submissions, we notify the council for the respondent states. Respondent 125 states that she shall file submissions within the course of the week. We notify.
23/7,
Please, my lords.
serial number 13, Srimati. 13,
But IA3, my lord, is for a direction.
In this case, my lord, I am appearing
To-
for the appellant. My lord, after hearing the caveatal, my lord, then interim order was passed, my lord. It is a required final hearing, my lord. Hence it
We
is,
had not
request the
filed
senior
caveat.
counsel.
Caveat was filed by other respondents. But certain portion of the land under dispute, my lord, was acquired by National Highways authorities. In view of the dispute, my lord, who is entitled to claim compensation, my lord, the National Highways have deposited the amount, my lord, before the principal district judge with an application, my lord, to adjudicate who is entitled to claim. That is also, that can be done only in, why that proceeding should be stalled, my lord? If they are taking adjournment on some ground, why should let that proceedings go on? Ultimately, my lord, if the district court decides who is entitled for the title and who are the legal heirs of the grantees, that can be done. Why should that proceedings, because of this, but the files is just a memo, writ appeal is filed, stalled.
So if that's the reason, so you are working out before which authority?
But before the Not before the deputy. But that has to be adjudicated only by the district principal district judge. Principal district judge Chitradurga. Before the civil court, that is what they have. National Highways Authority has deposited the amount. They have.
So it's akin to under the Land Acquisition Act 3031, the ownership of the.
Yes.
You are there before them.
Yes, all of us are before the court. National Highways Authority is the applicant before the district court to adjudicate the rights of the parties. That may be clarified. Let that be over. Nothing to do with that matter, just a submission was made. So court says status quo.
My lord, I requested the senior counsel Lakshmi Narayan, my lord. Yes.
Please.
What is he claiming in this appeal?
But they claim, my lord, they are the legal heirs of some grantee. The Leonard Singh, like.
So just 1 minute.
Please.
If they are claiming a rights from the grantee, and you are the subsequent purchasers?
Subsequent purchasers, not from that grantee. But is the legal representatives of one grantee are putting forward their claim in respect of the land granted to another grantee. That is the Leonard single judge.
But you may have bought or purchased it from an earlier purchaser.
Earlier purchaser.
That's right.
Please, sir.
So suppose, hypothetically,
Yes, sir.
he was to succeed in this appeal, what follows?
That would not affect our rights because the learned judge, my lord, has recorded a clear finding. I will regard to the records that the land granted to is the grantee, my lord, through whom he claims. My lord, is a different land. Kindly see the order of the land judge. Survey number 471/2. Good evening. Just 4 and 5. Paragraph 4 and 5 at page 31 of the paper book, my lords. Order.
Now you are claiming the land.
I am the original grantee's legal heirs, my lord.
Name.
What is the survey?
Survey number 471/2 and 471/1, my lord. They bifurcated. My lord, this land was originally granted in the year of 1956, one Guruvaya, my lord. 9 acres, 27 guntas of the land, my lord. That after the Podi, my lord, it is renumbered as 471/1 and 471/2. There, my lord, in 471/2, my lord, 4 acres, 31.
Are you claiming under Guruvaya or they are claiming under Guruvaya?
Guruvaya, we are claiming, they are claiming under Sannatimaya.
I am the legal representative of Guruvaya.
Guruvaya's son, my lord.
They have
brother,
sold the
Sannatimaya
entire extent of 9 acres land to some others, developers. They have already formed layouts and they have developed. They have sold. Now they want to put forward claim for this also.
My lord, Guruvaya was no children. Sannatimaya having a children's mother. Sannatimaya children have filed this petition before the Assistant Commissioner, my lord.
Kindly come to para 9 of the judgment passed by the judge.
But the only thing is Guruvaya's legal heir is Timmaya.
No. Guruvaya's legal heirs, my lords, no one is before the court. No one. 5 to 9. 5 to 9 this.
5 to 9, we are the legal heirs of Guruvaya.
Petitioners are legal heirs of Sannatimaya.
Petitioners were the appellants were the legal heirs of Sannatimaya.
Sannatimaya.
We are the legal heirs of Guruvaya.
Guruvaya died long back, my lord. He doesn't have the children's, my lord. He is unmarried.
No connection.
No connection.
They are claiming that Guruvaya's children's, my lord. Guruvaya has not married. That is there in the order's copies.
From whom you are claiming a right?
Sannatimaya, Guruvaya's brother, my lord. Yes.
Now between Guru Timmaya and Guruvaya, there is no connection.
Though both are brothers, my lord.
Even if they are brothers.
Yes, ma'am.
But you claiming under Timmaya and they claiming under
Guruvaya.
That means the properties are distinct.
No, my lord. See, there are two parts, my lord. They are claiming, Guruvaya is claiming, and we are claiming under Sarnatimaya, Guruvaya is Dadal, my lord. But my lord, that Guruvaya is, my lord, he is having the children's, my lord. They are not, he's a different persons, my lord. They are fraudulently, my lord. No children's, my lord. That is there in 1964 deeds also it was mentioned. And even Assistant Commissioner also stated that in his order, my lord, he doesn't have the children. Guruvaya has no children.
All the claimants, my lord, are before the parties before the principal district court, including them. So their title, their right has to be adjudicated there first in the civil court. Till then, they can't put forward a claim for somebody's land.
Para 10 में kind of.
What has been said is that the payment of compensation, typically payment of compensation.
Yes, my lord. We are also claiming, we are also party there, my lord. Their right was rejected. They filed an impleading application in the AA arbitration proceeding before a district court.
He has to.
No, not only that, my lord. We are trying the title also, my lord. The land was already resumed in favor of the legal heirs of Guruvaya, my lord. The Assistant Commissioner, my lord, by his order dated 1915, my lord, has restored the land in favor of the original grantee. All other persons, my lord, who are there by fraudulently, they are impleaded in the proceedings, my lord, saying that they are the Guruvaya. Even my lord, they are children of the Guruvaya. My lord, Guruvaya is not having the children, my lord. It is already the Assistant Commissioner also passed the order saying that Guruvaya has no children. In that regard, my lord, the argument is required to length arguments, my lord. I request the senior counsel Lakshmi Narayan to address the argument, my lord.
Even otherwise, lands are sold up.
They are saying that we have to approach the civil court, my lord, as per the PTCL Act, my lord. And there are judgment, my lord, we are not necessary.
Claim is made after 40 years.
Page 74, my lord. Order of Deputy Commissioner.
When is the proceeding before the PDA that you see that?
Well, now
2020.
I have
20, my lord, arbitration proceedings are pending. Yeah.
Can be given to understand
Yes.
the payment for compensation is pending there.
Yes, sir.
So he will also work out who has to be paid.
yes.
You are also there.
No, we have challenged the Assistant Commissioner, my lord. He has passed the order in favor of the legal heirs of Guruvaya. Deputy Commissioner rejected that Assistant Commissioner order, and the writ appeal also allowed. We filed a writ appeal that also dismissed, my lord. We have challenged the petition and this Deputy Commissioner order.
Are you there before the district judge where the aspect of compensation is?
Yes, we are before the. There are two parts.
Your rights, their rights will be worked out by there.
But because this Assistant Commissioner order, after the Assistant Commissioner order, my lord, land was restored to her. Tata was mutated in our name, my lord. After the Deputy Commissioner order, my lord, the position also given back to them, and Tata also changed. Hence, my lord, they have implemented in the proceedings, my lord. Hence, it is required, my lord, Deputy Commissioner and the reputation.
We want to know why are you there before the district judge? Why are you there?
As per the order of the Assistant Commissioner, my lord, we have the properties are all mutated in our name, my lord.
Right, so you are claiming compensation there?
Yes, my lord.
You are claiming?
Yes, my lord.
They are also claiming?
Yes, my lord.
So you have to work out there?
No, because the reputation and the Deputy Commissioner order, my lord, that it was quashed, the Assistant Commissioner order was quashed. That's the reason we are unable to claim. Without quashing the reputation and the Deputy Commissioner order, my lord, we cannot claim the.
Para 10 of the learned single judge order.
Their main point ground is, my lord, we have to approach the civil court. As per the PTCL Act, there is a bar under section 11, my lord.
commissioner order.
Page 73. It starts from 71.
There are two deputy commissioner orders.
The deputy commissioner order which was challenged before the London Single Judge.
Yes, ma'am.
Where is that?
Page number 137, my lord, annexure H, my lord. Annexure H, that is the order of the assistant commissioner, my lord. It's-
71. 71.
71.
Please, my lord. Seventy-one translated copy.
202 read, last one. What was under challenge is, my
I beg
lord,
your
at
pardon,
page
it is
19,
202,
my lord.
5/1/2022.
219, my lord.
202, my lord, annexure K, my lord. 202, annexure K, my lord.
219.
Annexure K.
19.
There are two orders, my lord. One is the annexure K and another one is, my lord, annexure. Yes, ma'am.
Which is that order of the deputy commissioner?
The 202 page
19.
number, 202 page number,
202 is the.
202 annexure K, my lord.
Where is the English translation?
In next,
English translation is at 219, my lord.
What does the deputy commissioner say here?
219, my lord.
He says, my lord.
Question.
Sorry.
Regarding the inheritance of the deceased.
No jurisdiction to decide these points.
Now come to page 240, 240.
240. Yes, ma'am.
Yes, ma'am.
Come to 240.
240.
If any
Yes, I have given to the senior counsels, my lord. Lakshmi
There are
Narayan.
also effective.
But the translation paper I don't have, my lord. All the other matter I have. The translations, it was not here. So,
No, no, this is, you see 240. We have 240.
You would
240.
Should I help you?
you have,
You read this.
Just show it to him. Now read this paragraph, last paragraph, in relation to the land.
in relation to the land in question, the original grantee is deceased. And there is a dispute regarding the inheritance of the deceased. And revenue courts have no jurisdiction to decide these points. Apart from this, the case has already been twice in these two regarding land alienations, and final have been issued. And as other subdivision, so and so, and not, it is appropriate to dismiss the above order because they say, if any dispute with regard to the decedents of the deceased grantee, the same shall be solved by filing a case before the competent civil court. For their grievance, in the background, all these reasons, the following order, appeal is allowed. Yes, this is the order.
This order has not been interpreted by the London Single Judge.
Yes, ma'am. Yes, correct. My,
What is wrong with the order of deputy commissioner?
yes, my lord, the court says they has to approach the civil court, my lord, as per my pleadings in the appeal, my lord, and also I have several judgment also I have stated as per the PTCL Act, my lord. It is a special enactment. Under section 11 also, we need not go to the civil court. And in that regard, Tahsildar having the power, the government has given by a circular, the government has given a power.
Now, you are also before the authority which will apportion the compensation.
Yes, ma'am.
Okay, that authority will also look into it, that who is entitled to the compensation.
Not only award amount, my lord, we are also claiming the land, my lord. We are the original legal heirs, my lord. They are fraudulent after the restoration by the assistant commissioner, my lord. They fraudulently, they have implemented in the appellate stage. Well, that I have filed a IA for showing this court that was not produced before the learned civil judge. It's a single judge, my lord. That has to be marked, that IA has to be allowed. They have 5 to 11, my lord, they have implemented there. They are not a party before the state commissioner, my lord.
Now, this is under the Land Acquisition Act.
Under the National Highways Act.
National Highway is not a party here.
Not a party here, not a party.
It's under the National HAI Act. Under the NHAIA Act.
Yes, my lord, land was acquired on the national highway.
So there is the question of claiming the land.
Yes, my lord, we are claiming land as a
NHAIA had
acquired part of the land, my lord. Only main part of the land was acquired. Remaining extent it is there, my lord, in the name of earlier the assistant commissioner was Kata, everything is mutated in our name. My lord, after the deputy commissioner order, my lord, the Kata was changed there.
But don't you think that even if you want to have the extra land,
Yes, ma'am.
the claim is for extra land.
Yes, ma'am.
Other than the land which has been acquired by NHAIA,
Yes, ma'am.
you still has to go to the civil court only.
No, I have the judgment in that regard, my lord. As per the PTCL Act, legal heirs cannot go to approach the civil court for any dispute, my lord, in this regard. Because the Tahsildar has given the power in the circular, my lord. This, I have only one copy I have given to the senior counsel, my lord.
There are disputed facts.
Yes.
Where will you go? Assistant Commissioner, you went. Deputy Commissioner, you went. Deputy Commissioner has said so. There is an issue, interstate issue between the legal successors of the gentleman. Now, these need to be worked out before a civil court.
That is
What is wrong in that finding?
there are judgment, my lord. We need not go to the civil court, my lord. The affected persons, my lord, the person who is in the illegal possession of the land, he has to go to the civil court. That is, my lord. Only, I have only one copy, my lord. In this judgment, my lord, Tahsildar has given.
Let the court look into your judgment. ಯಾರು ಬಂದ್ರು ಅಷ್ಟೇನೆ ನಿಮ್ಮ ಲಕ್ಷ್ಮೀನಾರಾಯಣ ಬಂದ್ರು ಅಷ್ಟೇ ಬಾ ಬಿಡಬಾರದು ಇವತ್ತು ಮಾಡಿಸ್ಕೋಬೇಕು ಯಾರು ಜಡ್ಮೆಂಟ್
ಅದು ಸೀನಿಯರ್ ಕೆಲ್ ಫೈಲ್ ಕೊಟ್ಬಿಟ್ಟೆ
ರೀ ಇರ್ಲಿ ರೀ ಇದು ಯಾರ್ದ್ರಿ
RSA.
ಯಾರು ಜಡ್ಮೆಂಟ್
This judgment doesn't say that the civil court on any issue which is otherwise covered under PTCL Act or would not lie before the civil court.
No, my lord, that judgment says whether the Tahsildar having the power or not to issue a legal heir certificate. So,
We are not on that.
Yes.
You are on who is the basically successor of this gentleman. These are disputed facts which need to be worked out before the civil court. That's what the deputy commissioner says. What is wrong in that order? That's what we are saying. The other civilian did not interfere.
Kindly pass on, my lord. I requested senior counsels. Kindly pass on.
This is pass on.
Lordship, in this matter, I feel for the petitioner, kindly pass over this matter, Your Lordship. I shall produce the receipt for payment of the court fee, Your Lordship. Much obliged.
15. Pradeep.
Yes.
Assistant.
Sixteen. Serial number 16.
Blank, man. Tomorrow, my lord.
Your lordships had heard this matter twice.
MR copy is available now.
Please, my lord.
Tomorrow. All right. Tomorrow ready to file the MR.
Regarding grant, my lord, they had not paid the upset price. Now, my lord, Medical Science Institute is
Much.
29-4. 17. Nitin
Apparent.
Prasad.
Early hearing application is filed by the other side.
As I appear for respondent number 1, I have filed the early hearing application.
Any date that your lordship pleases may be fixed. Yes.
Sixteen 7.
16.
16-7.
My lord, another request, a fresh wakalatnama has been filed on behalf of respondent number 1. A fresh wakalatnama on behalf of respondent number 1. My name may be reflected in the cause list. My lord, the other respondents are arbitrators, so I'm the one. Akash Sherwal, my lords. Yes, my lord. Yes, ma'am. Great. Much up.
18. Number 18.
Lord, 37 appeal, my lord.
There are applications filed for vacating the interim order. By order of 17/7/2023, my lord, after hearing parties, the interim order has been passed. So question of vacating it at this stage may not arise. Matter to be heard, my lord, the main issue is with regard to bank guarantee. But I had a bank guarantee in my favor, which is injuncted by the court, my lord, by the impugned order, to say that I should not invoke the bank guarantee. No, my lord.
No, my lord,
It's
there's
a
no arbitration.
original suit.
It's a regular suit, my lord.
Regular suit.
No. Yes, my lord. My short question, my lord.
My lord,
No, my lord.
My lord, performance guarantee and retention amount, my lord, securing retention amount, bank guarantees are there. 7/4, my lord, the matter was sought to be settled. We held a meeting on 7th of April. Then, my lord, I received, my lord, a revised offer according to me, my lord, in writing from the respondent on 11/4, which is under consideration, my lord. My learned friend today told me that it seems to have failed, is what he says, my lord. By instruction is
all settlement, my lord, we have, my lord, made attempts for over 2 years now to try and settle it. My lord, we have given them multiple proposals. They said you withdraw the petition, that is the only settlement that we are willing to consider. My lord, we have tried several times, and now, my lord, the settlement process has failed. So therefore, my lord, there is no further settlement process. My lord, my application today, my lord, is on a short question, my lord. Kindly see.
My lord, if he is making a statement, my lord, that the settlement process is, I don't have instructions so far as settlement is concerned, because 11/4, they gave me an offer in writing after our meeting, my lord, on 7th. My instruction, my lord, is we have to take my lord, from 104 crores, which was his original claim, he's now come down to 39 crores. That's
been my offer for more than a year. It's
main dispute is pending.
Main dispute is pending. Today, my lord, what's happened now, my lord, is
71 crores. No, it's a huge project, my lord. Although 71 crores looks very big so far as by itself as an amount is concerned, my lord. This, if you see it in the parlance of, this is part of performance. One is performance, one is retention money. My lord, whole dispute is whether the project was implemented by them, my lord, fully. My case, my lord, is that they did not complete the project by deploying the SCADA, my lord, which is something which I used for monitoring.
Yes.
Whether the DOC was happened, if it happened on what day, have they actually implemented? And my lord, also that I had to deploy a third party agency, my lord, for completing that process. We could not complete because they did not cooperate. All these are disputes, my lord, which arise. In the context of that, whether that retention money is to be.
It's a government organization. So far as the bank guarantees are concerned, in any case, if you succeed before the civil court, the money can still be recovered.
No, my lord.
Today is only the issue of bank guarantee.
No, my lord, kindly see, it is not as if they have a counterclaim against me.
It may not be.
They don't. So therefore, my lord, they don't have a money claim against me today. As of today, my lord, they don't have a claim against me. I am saying my bills are due. I have completed my work. You are refusing to certify that my work is complete, and you have kept me on for the last 10 years by continuing to direct me to keep on renewing these bank guarantees for no rhyme or reason.
Yes.
Once this money comes, their counterclaims are satisfied.
No, my lord. As far as even as on the date on which they have not made a money claim against me at all. They simply say no. You are now claiming that the work is complete. I don't agree with you. I'm encashing.
Cost of the visa is a bank guarantee which is secured by the bank guarantee to the extent they say they are entitled to.
Well, even in the written statement, they don't say that I have suffered any loss or that
or that, my lord, that money is payable to me. None of these things.
My lord, what happens, my lord, is
They're only saying that work is
not correct.
According to me, performance is complete. According to him, performance is not complete. And my lord, therefore, if performance is not complete, bank guarantees have to be kept alive. So they're continuing to be kept alive. The question is to be decided is, my lord, whether performance is complete or not complete. If I succeed, my lord, bank guarantees need not be extended thereafter. If they are right, my lord, I have to continue to extend bank guarantee. My lord.
They say very well. See, under the bank guarantee, the position is different. You have to go by the terms of the bank guarantee. That's a new part of it. They have rightly or wrongly invoked the bank guarantees. Your claim is that you have discharged your liability. Nothing is payable.
No, they have not invoked the bank guarantees. I have filed a suit, and in the suit, I have sought for an injunction. They have not invoked it. No.
Before, my lord, I could take recourse, my lord, they presumed that I might invoke.
No, my lord, there is not even a proposal to invoke. My lord, I have said, this is a matter that has been adjudicated. Please don't do anything.
No. What has happened, my lord, is, as my lord rightly said, my lord, the retention money is to be released only after, my lord, DOC is achieved and, my lord, project is completed. Lord, they came with a proposal to say, please release the retention money. I will give you a bank guarantee to cover that retention money, which I was entitled to hold till the entire process is completed.
So he's holding bank guarantee.
We, my lord, acceded to that request and, my lord, released the retention money, which as per contract I was, my lord, entitled to hold, took the bank guarantee. Now, my lord, after having taken that money, he says that I will go to, my lord, I'll seek an injunction and, my lord, see that the bank guarantee which was given to me against that amount is not to be invoked.
They have to succeed. Is there any prayer for return of the bank guarantee by them also in the suit?
There is.
They have to succeed. Its only thing is this. This is in contemplation if they succeed. Okay. What they have paid is they have also paid for the return of the bank guarantee, and possibly their claim would be that clearing of the final bills or the bills everything. Now, if they succeed, it's a question of whether how that order need to be implemented, whether the judgment or the decree which they will have. What is happening to him is, in any case, this is a government organization. Anything that needs to be paid, it can be done. But what we have been told is, they have not even invoked the bank guarantee.
Correct.
Lord, I have, Lord, if I have not, Lord, then the question will be, it's a mere apprehension. On the basis of an apprehension that I might invoke, he, my lord, approaches the court and says, my lord, that it will be irrevocable injury that will be caused to him. And based on that, he's asking for an injunction, my lord. Therefore, I'll make my submissions, my lord, on the issue of whether there was a cause of action. If so, my lord, in the facts and circumstances of the case, are there any special equities? Because, my lord, so far as injunction is concerned, my lord, there are judgments. Yes, it is.
What do you say on that?
My lord, the question as to whether or not monies would become payable under the bank guarantees. No, my lord, no, my lord, if
Lord, may I make a
kindly
submission?
See, today I have filed the suit, and to vilify me for having filed the suit, if they want to invoke this, that my lord is a different.
May I?
There was no there has never been a proposal. It is not their case that I owed them money. It is not their case that they're seeking to invoke the bank guarantee. I am saying, please don't keep me on this project for so long, and you're continuously asking me to renew the bank guarantees. I am not required to renew it now because I have completed it. I have stayed on. I have finished all my obligations. This is my prayer in the suit.
Let's assume for a moment that they may not have disputed anything, nothing of that sort. But going by the terms of the bank guarantee, which is not a contract relatable to the contract, can't they invoke it? Let's assume nothing is payable, or nothing is payable, or nothing is they can claim against from you. Other you are entitled to, but on the independent, on the strength of the bank guarantee itself, those conditions itself, if it is unconditional, can't they invoke itself? Keep saying that this invocation is bad.
My lord, if they had invoked the bank guarantee, my lord, then, my lord, what they have invoked is a separate contract between the banker. My lord, I respectfully agree, between the banker and them for making that payment. And then, my lord, the money will have to be paid because it is unconditional. But today, my lord, I am not on that situation. Today, my lord, it is not a case where that contract has been invoked, or that we are in respect of any of the an issue in respect of that particular contract. But today the issue is with regard to the contract between the two of us. The only issue in this case, my lord, is whether or not I have completed the work in accordance with the contract or not. Is performance complete or not is the only question. And for that purpose, my lord, I am saying not that, my lord, if they invoke it, will the bank be liable to pay? Yes, they will be liable to pay. But I am saying, please don't do it, because I am saying in the contract between you and me, this is today the performance is long complete. The continuous insistence that I keep this bank guarantees alive is unjustified. I am making a specific prayer that these following bank guarantees, but if it is found that I am entitled to the declaration, these bank guarantees be returned back to me. And so therefore, my lord, what is in question in this case is not the other contract. And therefore, my lord, I am saying that pending this dispute, my lord, one party should not be permitted to aggravate it, or, my lord, render any of my prayers also infructuous. Today, my lord, kindly see, if I say, please do not aggravate the position, do not seek to invoke that other contract, and I seek an injunction against them, but all that I'm seeking is that, my lord, we act in terms of our contract here, and, my lord, pending suit, my lord, status quo. That status quo should be maintained, that one party should not necessarily aggravate situations unnecessarily. Now, kindly see, if because I filed this suit, if they seek to now thereafter now invoke it, when they've never had a claim, even the suit they have filed written statement, they don't have a counterclaim. But on that's why I said, my lord, this is not an injunction that is granted vis-a-vis, my lord, banker and them and their rights.
My lord, if he makes that statement, it could be recorded, my lord, because I have received a revised offer on 11th. He says, my lord, that it's not going through. That's what my learned friend says.
States that the post settlement is paid. So what is the
No, may I, on the question of that intermodal, can I just take 1 minute? Madam, kindly look at the order that was passed by this honorable court. I'm sorry. Madam, kindly look at.
My lord, the suit is posted on 30th June.
I'll just take 2 minutes.
Meanwhile, my lord, the matter could be heard.
No, I'm just taking.
30th of June.
Can I just take a minute? If my lord kindly looks at the order that was passed by this honorable court on 17th, 17/7/23.
May I pass on the
23, my lord.
Yes.
Now, my lord, on 17/7, my lord, we were referred to mediation, and, my lord, kindly see the last part of the order, my lord. My lord, we sought, Lord, in fact, we sought, not them. We sought that since the matter is presently being settlement is being discussed, my lord, let proceedings not be, because the learned judge in the commercial code is insisting, my lord. And so, my lord, pending mediation, a stay order was passed. Today, my lord, on the question of bank guarantee, my lord may decide one way or the other, but it has no bearing as far as the proceeding is concerned. Now, my lord, there are certain preliminaries that we have to complete. We need to carry out some amendments. We have various things, my lord, before the matter set down for trial. So, may I request, my lord, that the interim order not be continued any further, because the purpose of the interim order was to facilitate mediation. Now, my lord has already recorded that, my lord, settlement process has failed. Therefore, my lord, at least I will finish those preliminaries, not.
Let's see the order which has been
My lord, the impugned order, my lord, is at page. May I request my lord to kindly look at page 45. The operative portion is at page 74.
Yes.
my lord. So the proceedings, not the order, not the order. So, my lord, proceedings, I will complete some of those preliminaries. My lord, there's some amendments to be carried out, a few things. My lord, so, my
There's
lord,
no such
I'm only
application.
saying that we can proceed with those things.
Matter is posted
It has
on the
nothing to.
30th. Order as it indicates, my lord, after hearing that order is passed to say that proceedings are stayed. My request, my lord, is to take it up somewhere in June, my lord, before 30th, so that we can, lord. Yes.
No, my lord, we intend, my lord, those applications for amendment.
There is no
etc., we have to
application
move
filed
them.
as
No,
on
my lord,
today.
there is a, my lord, whether, irrespective of how this matter goes, it has no bearing as far as the proceedings before the court below. The question is,
Staying of the suit, how is going to help you? Not going to help any of the parties. The suit must go on, but there is a larger issue in the suit on the contract itself.
correct.
Who was at fault, who was not at fault. But your apprehension is that in any case, the court has restrained you from invoking the bank guarantees. Okay, that's all. Nothing on that. It's on you. So it's only this thing, you will not invoke the bank guarantee till such time the suit is pending. So today, the staying of the proceedings, how is going to help either of the parties?
My lord, in the meanwhile, my lord, we try to have this matter settled. Now, my lord, only today he is making a statement, my lord. I was under the impression that the process is still on. Now he has made a statement, my lord, that the settlement process has come to an end. My lord, my request, my lord, is as on today, after hearing parties, my lord, that order was passed to say the proceedings will be stayed. Therefore, my lord, my request is to have this matter in June, because it will not affect him in any manner, because the date fixed by the trial court is 30th. Therefore, my lord, let the status quo as it remains today, let it continue till any day in the next my lord, June, so that, yes.
My lord, this IA for vacating that order, my lord, I filed it way back in January. My lord, by now, my lord, substantially, at least the preliminaries with respect to, my lord, the amendments, etc.
It will not change the
no, my lord,
situation.
I wish to advance the matter and finish the preliminaries. My lord, after all, my lord, there's nothing that turns on this proceeding in as far as suit is concerned.
Why we are saying even if we advance the date before the trial court, so it's only the interim order is there restraining you from invoking. Okay, as long as you are not invoking it, I think they will not have an issue, because the matter in the suit can continue, or the suit can continue on any applications on that will hasten the process before the.
My lord, what will happen, my lord, is if that order is vacated, my lord, there will be no urgency for, my lord, consideration of this appeal, my lord. We know practically what will happen.
I have not taken
this
one
is
date.
Because this order has been passed, my lord. There will be some urgency on for the other side also to expedite, my lord. Normally that's what happens, my lord. Therefore, my request is till next date, let that order continue, my lord. After that, my lord, I will file synopsis in the meanwhile.
Madam, kindly
Yes.
look at it. Madam, it's not a fair statement. Kindly, madam, we have not once in this proceeding even asked for time as far as this matter is concerned. Therefore, to say that, madam, keeping
because
that
there is a stay
proceeding
order.
stayed is essential to arm twist me into.
We will say that order is vacated. We will also say that suppose your apprehension is he may invoke, either Mr. Sriranga gives a statement, he will not invoke the bank guarantees and vacate the order of stay of the proceeding, so that if people can go ahead, whatever the application and that can be worked.
That will be my request, madam.
That's the only thing, Mr. Sriranga. Very well. There is an order restraining you from not invoking. Then, according to him, there is nothing remains in that appeal once that the statement is recorded. He said, see, one thing is there, very you have not even invoked the bank guarantee.
That's true, my lord. Then there is no cause of action for them to simply go to civil court and get an order against me.
But is it now you are instructions that you intend to invoke the bank guarantees?
Lord, before I could not take a decision on as to whether that needs to be done or otherwise, my lord. That question did not arise because they came with a proposal. There was mediation. We tried to settle it. There was a serious attempt to, my lord, settle it. As I pointed out, my lord, in the process, they also realized that most of the claims that they have made do not exist. Therefore, the claim came down, my lord. It was not a futile exercise. My lord, if today they say that they are not ready, then, my lord, I had a right to keep the retention money, which I had to use for getting the work done, which they had not done. Today, my lord, I was, my lord, just to, my lord, be nice to them and acceding to their request, I released the money which was in my hand by taking a guarantee. As soon as he gets that, my lord, he goes to court and says, you cannot invoke it.
No.
Under the contract, I had a right to retain that money. If I had that money, my lord, the question of making a counterclaim will not arise. Why should I spend money paying the court fee, making a counterclaim in respect of the money which is belonging to me, which is secured by the guarantee, which I can use to get the work done? As a matter of fact, my lord, I had to engage third-party agencies who are his subcontractors to, my lord, get the work completed. No, my lord, the contract is current according to them. They are saying, my lord, that they are not required to complete the work.
No, my lord, there's no termination. The question is only of whether performance is complete or not.
Yes, yes. Therefore, my lord, have this matter somewhere in. Yes. Great.
18.6. Number 19.
For the appellate in this case, please, Lord. Muller.
My lord, appearing for the respondent, my lord.
Appear for the appellate in this case, please.
Yes. No? Oh, sorry, sir. Sorry.
That's what I
Sorry.
said. Enjoy your seat. Please.
Yes.
Lord, my learned friend has filed an application seeking vacating of the interim order.
Whether I have to submit your.
Please, my lord, you submit.
Yes.
Lord, this is a contract with regard to transferring of the managing license from one in the subject partnership firm from one management to another management. That is the crux of the point. Before that, Lord, it is very sad to submit on 20th of April 23, stay of the injunction order was granted by this court. And that day, court made some observation. Para 4, learned counsel, I am for respondent 1. 20th April 23, para number 4, last 2 lines.
20th of
April 23, para 4, last 2 lines. I could not be present on that day due to some unfortunate circumstances. I was traveling by my e-bench car. There was heat on the road and obstructed me to come out from the traffic. Letter counsel for the respondent number 1 was unable to point out any agreement in writing in that regard. On that day, neither myself nor my colleagues nor I authorized any proxy counsel to represent. How come this person, unknown person, represent that is mischievous? That is how that person who appeared in my name has traveled in the boat of the appellate. That is how it has happened. However, it is sad to submit, I brought your lordship kindness. Now, coming to the point, Lord, the appellant defendant is a partnership firm, and the first respondent plaintiff is also in the business of money. Both parties are operating in the same business field. They are well known to each other. They are not new. What is happening in money license mail is that they will obtain license. Afterwards, they will, in fact, there is selling in the process as per the process known to law. They'll sell as per the process for profit. That is what is happening in the business. That is however it may be. At page 6, document 1 filed by the respondent 1. Annexures are in the series of appellant. Documents are in the series of respondent 1 appellant. Page 6, document 1, my lord. In the IA filed by the respondent 1. IA filed by the respondent 1 seeking vacation of the TR.
Yes.
Lord, this is.
You have filed.
Yes, my lord. Respondent 1 plaintiff. Lordship got it. Page 6, in page 6, document 1. This is partnership form in the name and still Shiga Exports. Shiga, it is a family partnership. And partner serial 3, Sridhar Babu. Partner 3, Sridhar Babu Mela.
Yes.
Partner 5, Meera Sridhar Babu, his wife. Partner 7, Yashash Sridhar Babu, his son. Other partners are nominal partners. In fact, it is a family-run partnership firm. Managing partner by Sridhar Babu, Shiga Exports. And next page number 7, document 2. Navishri Minerals, that is also partnership firm. Page 7, my lord. This is also number 1, Sridhar Babu, his wife Meera Sridhar Babu, his son Yashash Sridhar Babu, 5 and 6, 4, 5 and 6. 5 has transferred the license in his name, which I am going to speak in details just later. So this page 6, Shiga Exports partnership firm by Sridhar Babu managing partner, and another partnership firm, family-run partnership at page 7, Naveshri Minerals, same Sridhar Babu is the managing partner. Now, kindly, page 8, document 3, my lord. See, this Naveshri Minerals partnership firm, all the partners, even GPA, to deal anything in the business line to the managing partner, Sridhar Babu. All the partners. Now, what has happened, my lord? Here, there was an understanding between the two, between the appellant, defendant, respondent, plaintiff. The respondent, the appellant, defendant want to sell this license by way of transferring in the same in the name of the same name of the partnership firm, inducting them the respondent defendant, inducting them into the partnership firm, otherwise they will go, license will stand in the name of the same Naveshri. That is how this legal process is. That being so, I'm sorry. Again, Lordship may visit Annexure C, page 79 of the appeal memorandum. Annexure C at page 79 of appeal memorandum filed by the appellant defendant. Annexure C, page 79. This is the Lord. Originally, the license was standing in the name of the Balakrishna, son of Gopal Singh, Balakrishna, which was transferred in the favor of Naveshri Minerals. By the process that Balakrishna, in whose name the license was standing, it was transferred, he was inducted as partner in the Naveshri Minerals. Somehow or the other, Balakrishna's license was transferred to Naveshri Minerals, for which appellant defendant is the managing partner. Naveshri Minerals is by managing partner by Sridhar Babu. Sridhar Babu. He is the managing partner for the Advisory Minerals. He is the partnership firm in question now.
So it has been transferred in this name of this firm.
Yes, by due process of law. Annexure C. It was standing in the name of the Advisory Minerals by Sridhar Babu, managing partner, in whose name gift is issued by all the partners to give any money. Annexure next. That being so, Annexure G in the appeal memorandum at page 87. Typed copy 88, next page, Annexure G. There was understanding between the appellant, defendant, respondent 1 plaintiff. Appellant, defendant 1 is the vendor, respondent plaintiff is the purchaser and getting otherwise transfer of winning asset. That is the issue. There was understanding, as they are close friends in business field, to transfer this winning list for a sum of 2.10 crores, for which this 15 lakhs he asked advance. Can you see 29/11/19, 15 lakhs was transferred. He has requested the purchaser to transfer is Shiga Exporters firm. That is also family run. He is only managing partner for both the partnership. Accordingly, it is transferred. Next, he has issued unconditional bind over Milan.
The account was in whose name?
Pardon me?
The account.
He is the vendor appellant asked his friend, respondent in the plaintiff, he was in need of funds in Shiga Exports. Please transfer that. I will give undertaking to transfer the license in the mineral Advisory business to your name. That was understanding, which I am going to deal in little bit more detail. Of receipt of these 15 lakhs. May I go on? 15 lakhs has received. The appellant defendant received.
What was the suit filed for?
Injunction suit.
For what? What was the nature of the injunction sought?
Many reliefs were sought. Many reliefs. Thank you. Eight reliefs were sought, my lord. Apart from injunction, several reliefs were sought.
The Lord will get that page 111, please.
Apart from seeking injunction, permanent injunction, several requests, prayers were made. Of receipt of 15 lakhs into the account of the vendor appellant defendant, he has issued unconditional bind over annexure F, page 90. Annexure F, page 90.
What is the submission?
Lord, the contract to sell in the as per the process known to law is subsisting, valid, continuing bind over.
Contract between who?
Between the appellant defendant firm, vendor, and the respondent, first respondent, plaintiff, purchaser. But he is not doing so as per his bind over. Corroborative bind over, not one bind over. Bind over after bind over, bind over after bind over, undertaking promise after promise. Not one bind over.
Not one.
Not one bind over by the appellant defendant. series of undertakings, series of promises, documentary evidences, but he is not going by that. He is a series of undertakings.
What is the effect of this interim order?
Now what has happened, my lord, on legal analytics?
Where is the application? You were the plaintiff?
Yes.
Where is your application in the 39(1)(2)?
Lord, actually, before that, my lord, I may draw kind 1 minute.
You will see that.
Yes, 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 yes. Yes, I have
application.
Yes, yes. 1 minute.
Page 125, please.
No, no, 1 minute. Before that, my lord, at page 169, Annexure N, this is the trial court order on the based upon legal analytics, clear reasoning. Page 169 is the order. Operative portion is order of the trial court.
Which page you said?
169.
It's 125, please.
No, 1 minute. I don't miss it before. I'm going to, before that, explaining the query, it is necessary to draw the kind of attention of the court. 169 is the order, operative portion is 181 by the trial court. 181. Few lines I am permitted to do, 4 or 5 lines of the trial court observation.
So, you have been restrained from doing undertaking quarrying work.
Yes.
You have been restrained from undertaking the quarrying work.
No, what happened of late?
No, he has been restrained. Yes, you have been restrained. Yes.
That he is restrained. Now, on the basis of the stay order, we started mining with heavy machineries, 24 hours mining and at the cost of justice dispensation.
That's the effect of the stay order.
Yes. That may kindly observe. Trial court observation, 3-4 lines. Page 181.
What is the period for quarrying? How much is the period?
Now they extended up to 50 years. First it was granted for 20 years. Admittedly, it was extended for 30 years. Now as per
When is the last, which year, till which year?
it is there.
In the year 2028.
No,
Because, one minute, please, gentlemen. The lease initially was granted for a period of 5 years in 1978. Thereafter, due to changes in the law, etc., the lease came to be renewed in the year 2001 for a period of 10 years. Thereafter, my lord, the certain provisions.
However, the lease is continuing subsisting until 2015 or something. It is subsisting.
Okay.
Now, my lord, permitted to draw lordship attention to page 81 up.
What is the real dispute between both of you?
Lord, that I am going to explain within 5 minutes.
What is the dispute?
Lord, seriously, he has promised in writing, so I will transfer the license to you. Series, not 1 or 2, 3, 4, several in document evidence. But he is not doing that. Now, because on the strength of this stay order, he started mining with heavy business 24 hours. At no fault of the respondent one plaintiff.
Where is that promise?
Yes, I am going to.
Shows that.
Yes. Series of promises. typed copy of Annexure E at page 88, he receives 15 lakhs advance, transfer consideration of for the lease of the mining. Page 88, Annexure E. 29/11/18, Shiga exports 15 lakhs. He admits that. After that, he is doing an undertaking. At page 90, Annexure F.
So you have paid him.
Paid online.
You have paid him.
Yes. He has given undertaking receipt.
It was returned.
Page 90, Annexure F. Page 90, Annexure F.
Yeah, we have seen that.
15 lakhs as advance by way of transfer from respondent plaintiff towards transfer of funds, obviously minerals, to Abdul Hafiz, respondent plaintiff, first respondent plaintiff, for a consideration of 2.10 crores. Shiga exports, because he requested him to transfer funds to Shiga exports, for which he is managing partner, and he is managing partner for obviously minerals. However, he has paid it over. I received 15 lakhs, I will transfer the license to Abdul Hafiz, respondent plaintiff once.
This amount has been paid for the transfer of the quarrying license, lease, or the partnership itself.
So what happened? This is basically for transfer of lease license to the Abdul Hafiz, respondent plaintiff. The process known is, first they will induct the purchaser into the partnership firm, obviously thereafter they will fit.
But page 90 says transfer of our firm.
It is means and includes transfer of license in fact.
Right. Simple. But it is only largely it was basically the transfer of the firm.
Yes. In which name the license is there? In the firm name license is continued. Afterward, this is first bind over. Next bind over, my lord. Annexure D, page 85. After receipt of 15 lakhs advance, after giving this undertaking to transfer
The quarry license is in the name of the firm.
obviously minerals. Yes, undertaking, I have received advance.
But after this change, the partnership has to be reconstituted.
Yes, that is the process of law. That is bend over. That is one of my prayer in the before the telephone, among all the prayers.
Okay.
Now, my lord, may kindly listen.
Who would be the other partners?
His family members.
No, after transfer.
After transfer, the exit.
Reconstitution, who would be?
That is between their arrangements. That is the later issue.
So other partners would remain and you will join them?
Join them, or other parties may quit, anything could happen. Totally, the license will be transferred in the same name and shell of obviously minerals, headed by this purchaser.
So you want that quarrying license or the lease should be there? That's all.
Yes. License will continue in the same partnership for obviously minerals, but management will change. It will come to the hands of the purchaser, respondent one plaintiff.
you and them.
It is express or implied. I am going to demonstrate that in little later. I am going to explain that. I am going to demonstrate that agreement. Express or implied both the ways.
Is there any written agreement?
It is there. Just I read it. Annexure F90 towards received annexure F90, page 90. Conclusion. 15 lakhs received towards transfer of our foreign obviously minerals. In each name the license consists. Towards 15 lakhs received towards transfer of our foreign obviously minerals to Abdul Hafiz, respondent plaintiff, signed for consideration of 2.10 crores. Rabbit 15 lakhs received.
So this is the only receipt you have. This is the only.
This constitutes a clear understanding, clear benchmark. Corroborated by several subsequent developments, subsequent benchmarks. Lord, my lord, may kindly. Yes. Kindly annexure D, page 85. Page 85, annexure D. Page 85, annexure D. Lord, the appellant defendant vendor writes to the sub-registrar of Assam, stating like this: with respect, sub-registrar, district registrar, Assam, authorization to release the registered document of transfer of Form G, Pari, lease issued by Director of Mines and Geology. That is standing in the name of the Balakrishna. Just I read it. The license transferred from Balakrishna to these Nabeshri minerals, that is to be registered by paying the necessary stamp duty and court fee. The vendor writes to the registrar, please issue that transfer registered deed to this buyer, purchaser, respondent one plaintiff by collecting necessary registration fees. With respect to the above said subject reference, we authorize Abdul Hafiz, that is the purchaser, respondent one plaintiff, Sayyid residing so and so, to collect the registered document and also to pay the necessary fee to release the document. He is authorizes the purchaser pay necessary fee and collect the registered because he has paid the advance. He is entitled to purchase or transfer the lease. This is the third corroboration. Next, still stronger. That is another interesting by our page 91, annexure G. Annexure G. He sends draft agreement by email.
What is the state of the suit?
Suit, injunction order granted against the appellant vendor.
What is the stage?
State now the injunction granted, he has come before this court, challenging the.
No, what is the state of the suit we want to know?
No, it is to go for framing issues and.
The issues are not framed. Not because of the interim order that is granted by this honorable court.
The state order is there.
The state order, no, there is no such order.
Now, in view of that.
One minute, please, Lord. Lords may now kindly see the order.
Permitted to complete, my lord.
Please.
Please. Issues to be framed.
So the injunction which has been stated.
Yes, my lord, injunction.
The suit has not been stated.
Suit can go, my lord.
So who has stopped the suit?
My lord, my learned friend.
No, I have not stopped. I have not stopped.
Why should I stop, my lord? Let the suit go on. I have no objection at all.
It is only a flimsy allegation against.
No. Let the interim order, my lord, kindly see the application that is filed by my learned friend.
You are quarrying on the land?
Yes, my lord.
It is very.
It is valid only up to 2028.
That's right, but the only thing is now. You have returned the amount.
Yes, my lord, I have already written the amount.
I will come to that point.
My lord, either let me.
I will come to that point. I will come to that point. What happened? He has returned that amount
asked him, yes.
Without being asked unilaterally as transferred, unconditional, without any stipulation. Currently, it transfers to my account.
This is the only agreement you have put it. Page 90 is the only agreement.
Let me check jointly so many other subsequent documents.
Which are those?
Yes, I'm going to tell you that.
To us.
He has handed over that they will transfer the nearby minerals to the purchaser plaintiff name out of 2.1.
Yeah, we have seen that. Page
Yes,
90.
next page. And he has also issued sub-petitioner issued license to the hands of the purchaser, respondent and plaintiff, affirming the contract to sell. Affirming the contract. Next is very stronger document. Page 91, Annexure G. Annexure G, page 91. Transfer just page number. Transfer of 15 lakhs. Return.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿದ್ರಲ್ಲ ಮಾಡಿ ಇವತ್ತು ಪೇಪರ್ ಮುಗಿದಲ್ಲ
ಹೇಳಿ ಅದನ್ನ
ಕೋರ್ಟ್ ಅದು ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ.
Which page you are referring to?
Lord, page 91, Annexure G.
Yes.
Lord, of receipt of this advance of 15 lakhs after buying out to transfer the license in the name of the parties to farm and authorizing him to collect the transfer deed from SR. And again he sent another email. Please, in connection with the conclusion of the sale of transfer of the license, he is sending by email draft agreement. By email. See, 26 to 2020. Page 92 to 94, draft agreement he sent by email. The vendor firm, appellant, defendant. He says, "This is the please approve this agreement so that we can undertake to perform the process of induction or incoming or going water. That is subsequently we can do it. Please approve this draft." He sent by email, which upon
Yes, ma'am. Yes.
He sends a draft in the course of transferring the license from this appellant, defendant, vendor to the respondent and plaintiff as purchaser, which confirms he is duly bound to transfer the partnership firm license to his name. Draft.
Who are the parties?
Parties. He has sent a draft agreement.
Who is the first party, who is the second party?
He has kept 1, 2, 3 blank, but in the forwarding email, he clearly says, the party this has been transferred yesterday in this name from Balakrishna to Negotiator. I have attached the draft agreement for your reference once again. Can you revert back immediately to Abdul Hafiz? Here it is there, 2 address. Top right. That is respondent one plaintiff purchaser. Top right to Abdul Hafiz. Is the purchaser, respondent one, defendant.
Yes, right side, who has written this is.
This one appellant defendant, Ganda. He says, please, in connection with the commitment to transfer, I am sending the agreement, please approve this, so that we can conclude the transfer. That being so,
Yes.
next concluding point here. Page 103, annexure H1. Here, after a draft was approved in between the parties, suddenly he takes U-turn, that appellant defendant. Here, I have again that advance amount which he has received towards the sale conservation, part of sale conservation, he returns unilaterally, arbitrarily, voluntarily, without any stipulation conditions. It is not asked for because the appellant defendant told his friend purchaser that please keep 15 lakhs with you. I will take at the time of conclusion of transfer, I will take total amount of 2 crores 10 lakhs. Why to take bit, you keep it with you. That is why he has not put any condition. I have transferred 15 lakhs only to Oriental Granite, that is Abdul Hafiz respondent. So I am returning, that's all. Neither he has cancelled nor he is permitted in law to cancel unilaterally without meeting of two minds of the vendor and purchaser. He simply transfers with understanding, you keep this back at the time of conclusion of your transfer, you please pay 2.10 crores at one stroke. This transfer is voluntarily, unilaterally, arbitrarily, without being asked and without any condition stipulation. So by returning this 15 lakhs, the contract to transfer is cancelled. It is not there. Now he can put such condition unilaterally, arbitrarily. Therefore, I am agreed by that. 15 lakhs, if you put condition, 15 lakhs returned, the contract is cancelled. That is not there. Even he is not permitted to K9. Concluding point, my lord. ಅರ್ಥ ಆಯ್ತಾ? ನಾನು ಹೇಳಿದ್ದು ಅರ್ಥ ಆಯ್ತಾ? ನಾನು ಹೇಳಿದ್ದು ಅರ್ಥ ಆಯ್ತು, ಸಬ್ಮಿಟ್ ಮಾಡಿದ ಆರ್ಗ್ಯುಮೆಂಟ್ಸು ಅಂತ ನಿಮ್ಗೆ Now concluding point. Page 181 court observation, operative question. While granting the injunction order against the appellant defendants. Page 181 operative question.
Yes.
From bottom fifth line, my lord. From bottom fifth line.
Yes.
It is the case of the plaintiff that as per the gazette notification produced by him, body license has been extended for a period of 30 years, now it is 50 years. On the other hand, defendants assert that no such license is extended in their favor and the application scheduled property belongs to government. This version of both the parties establishes that there is a tribal issue, which is nothing but a prima facie case. When there is a prima facie case, it is probable that plaintiff is entitled for relief for temporary injunction. Because of the contract filed over to sell the license is still subsisting, valid and legal. Therefore, he has to, he cannot go, he take U-turn in violation of a series of officers. So that my humble prayer is to vacate this.
Yes, you will hear for who?
My lord, I appear for respondent 3, 4, 6 and 7.
Same family members.
Partners, please, ma'am. Partners of the appellant firm, my lord.
Do you have anything to say on this?
My lord, I'll have to file. I have not received a copy of the vacating stay IA, my lord. I'll have to file my objections.
All family members, my lord.
It's all right.
Family members. It is there, and the past later it can be seen. The respondents quoted are family members of the appellant defendant vendor.
Give her a copy.
Your family members.
3, 4, 6 and 7.
3, 4, 6 and 7, please.
6 and 7 are not the family members of the
They are
partnership.
partners which are left, they are left to go out of the partnership in due course.
They are only the partners here.
Although the other thing is partnership first. Is it a registered partnership?
Yes, yes.
Yes, ma'am.
Page, I filed that document.
You give her a copy
Please.
of the application.
On prayer, my lord. They are 24 hours mining with heavy machineries at the cost of the loss, irreparable loss to the respondent when plaintiff. Interim order vacating interim order may be passed.
But we have to hear them also, no?
Yes, interim vacating order, because they are night and day cleaning the mining, entire mining. Nothing will be left over to the plaintiff.
My lord, I'll have to take some instructions, my lord, because I
Yes,
didn't
yes,
have a copy.
I'll give.
I'll take some instructions, my lord. Because this IA is filed after 2 years of granting the interim order.
No, what he says is, maybe for 2 years, they were not doing any quarrying.
They are doing query. Photos has
No. We were carrying on quarrying operations right from the. Yes, my lord. We have been continuing quarrying operations.
Stay order by the trial court,
Yes.
except during that period.
Yes, my lord. Because because the lease was, the provisions of law under the Karnataka minor mineral concession rules is that by virtue of a promulgation of granite conservation and development rules, my lord, the lease which was granted in the year 2001, it was a renewal. It was granted for a period of 10 years. By virtue of operation of law, it was deemed to be continued for a period of up to 2021. My lord, during the subsistence of the lease, my lord, the central government Mines and Minerals Regulation Development Act was amended. Section 10A was amended. In parameters with that, my lord, the lease of the petitioner has been extended for a period of 50 years from the date of original grant from 1978. In between, we were not able to work. From 1978 to 82, we have worked. From 82, there was prohibition under the law. It came to be renewed in the year 2001. It was renewed for another period of 20 years. From 20 years to 50 years, from 1978, it is granted. My lord, so my respectful submission. No, my lord, he doesn't know the law. He doesn't know the law, my lord. He doesn't know the law.
Very sorry, do not make allegation like that.
Please.
This is not fair.
I'm sorry, my lord. I'm sorry, my lord. I'm sorry. My lord, I'm sorry, please, my lord. I'm sorry, please. My lord, now kindly see, my respectful submission is, this affidavit is filed by the advocate himself and not by the party. My lord, now kindly see.
In support of the application?
Yes, my lord, the present application which is filed before this honorable court is not filed by the party. It's
Protected in law, civil rules of practice. Not barred. It is not barred in civil rules of practice.
But how would you vouch for the factuals, Adjournments? How would you relay your knowledge to the factual scenario in the affidavit? You will be only giving those factual aspects must be given by the client only.
Two ways. There are two ways. I am the counsel before the trial court and the instruction from the this respondent one plaintiff. I am authorized to file this affidavit on his behalf, which is not barred in civil rules of law.
You see your paragraph 1. How can you impute knowledge to yourself saying that you are fully aware of the facts and circumstances? Where do you say you have been told?
I am fully aware. I am the counsel before the trial court and
have you seen the scenario at the point where the calling is going on?
Yes, I produced the photos also. Page 19 and 20. Document 5 and 6 filed along with the.
Okay, give her a copy of the application.
Yes.
Ma'am, when will you file your reply to the application?
My lord, I need to take instructions, my lord.
No, we want reply to come, that's all.
Please, my lord, I'll file my reply. I need some time.
What is the good name? Mr. Nagaraj.
Dr.
Nagaraj. Just give her a copy today. You can ask her to file a reply. You filed your reply?
No, my lord, I have not filed. Because there is one reason, my lord. My lord, so now kindly see the affidavit filed by my learned friend, Dr. Nagaraj, at page 18, please.
Page
18, your own application.
Yeah.
Please, my lord, so now kindly see. I, Professor Dr. S. Nagaraj, the counsel for the above, first respondent plaintiff do hereby solemnly state and affirm on oath as follows. That I am the first respondent plaintiff in the above case, and I am fully aware of the facts and circumstances deposed here. I am the first defendant, plaintiff. He must say that I am the advocate appearing for the page 18 of the application. Application, which is please, affidavit, the application filed. Please don't interfere, sir. What page number mistake? Page 18 of the application which is filed for vacating the interim order, please.
See, our affidavit, we are reading paragraph 1.
Yes, ma'am.
It says, I am the counsel for the above respondent number 1.
Yes. Then that I am the first respondent plaintiff in the above case and I am fully aware of the facts and circumstances deposed thereunder. Next, my lord. That neither myself nor any of my authorized representative proxy counsel had appeared before this honorable court. My lord, this is the
21, my lord, page 21. Ink page 21.
Yes.
But how do you say so, Dr. Nagaraj?
Lord, on the day what happened, I could not be present in the court due to.
But how do you say I am the first respondent plaintiff?
Typographical error, my lord. Typographical technical error. The advocate and the client, two bodies, one mind, one heart. It is a legal fiction, my lord.
Okay, did he give her a copy?
Yes.
That apart, I will like to bring my lord certain things to this and the notice of this sample court, please.
1 minute.
Please.
If you file an affidavit, you are filing with responsibility. You will not allow all these things.
My lord, yeah, human error, unintentional, inadvertent typing error has happened.
We will not take it when an affidavit has been filed by Professor Dr. S. Nagaraj. Simple.
My lord, it is in the legal fiction. I'm sorry, typographical error. I apologize. I will.
It's not an apology. You must be corrected. We will not allow this
Please,
affidavit
my
to
lord.
be recorded.
Please, my lord.
And give her a copy. Yes, what do you say?
Please, my lord. Further, please, my lord. That neither myself nor any of my authorized representative, proxy counsel had appeared before this honorable court on 24/2023. But it is observed by this honorable court that the counsel for the above first respondent appeared, who in fact admitted the version of the above appellant and first defendant in the same boat, and hence as to shock and disguise, it appears that a foul game came to be played in behind. My lord, that I don't know, my lord, that he has to explain. I will come to that point, please, my lord. My lord, only see. Wherefore, the first respondent plaintiff praise, this honorable court be pleased to pass an order as to take this memo on record, and in further be pleased to pass an appropriate order in the interest of justice. One minute, my lord, I will not argue, my lord.
Immediately withdraw this affidavit, my lord.
1 minute. We will not interrupt. Just hold on.
Please.
No, I object for withdrawing this affidavit, please, my lord. My lords may now kindly say, what does he mean by this affidavit? He steps into the shoes of the plaintiff and makes this
Trivial issue, making mountainous level.
My lords may now kindly see, my lord. The order came to be passed on 20.
Were you there in the court on 24?
Yes, my lord. He was present, I was present, and the other advocates were also present. Because the order, my lords may now kindly, 1 minute, please.
I have to answer, not you.
Please say, my lord.
I have
1 minute. You will file your reply to the application.
Please, my lord.
Give me this affidavit.
Please, my lord.
You will just give a copy.
My lords may now kindly see page, 1 minute, one fraction of a minute. Page 2 of the order passed by this honorable division bench, please, my lord. Page 2.
Yes.
Professor S. Nagaraj, counsel representing for respondent number 1, wide order dated 1/4/2023, has filed his wakalat. Thereafter, my lord, 1 minute, sir. You have certified copy now. My lord, 24/2023, my lord. The interim order passed in this appeal. Respondent. My lords, may now kindly see the order, please, my lord. Lords, may kindly see the order. Heard the learned counsel for the appellant and the learned counsel for respondent number 1. Respondent number 1 is Dr. S. Nagaraj. IA number 1 is filed seeking condonation of delay 64 days in filing the appeal. No objections are filed for this thing. Accepting the same shown by the partner of the appellant firm in the affidavit filed in support of the application, delay of 64 days in filing the appeal is condoned. IA 1 by 2020. Please, my lord, the next, my lord. The next paragraph, learned counsel for respondent number 1, that is submits that the amount paid by respondent number 1, plaintiff in a sum of rupees 15 lakhs has been refunded to him by way of NEFT. It is submitted that the said amount has been paid by respondent number 1, plaintiff, towards admitting him as a partner in partnership of appellant defendant number 1 as agreed for a sum of rupees 2.10 crores. The prayer sought for by the respondent number 1 plaintiff is including him as one of the partners in the appellant firm so and so. Learned counsel for respondent number 1, my lord, was unable to point out any agreement in writing in that record. My lord, on that day, my lord, my learned friend was very much present in the court, because this is a false affidavit that is. Please.
My lord, I was not present, none of my colleagues present. Otherwise, I would have submitted all these things.
But this issue has to be seriously looked into, please, my lord. Please.
Issue. Yes, please.
Be given to the learned counsel appearing for respondent number 3, 4, 6 and 7.
3, 4, 6 and 7.
3, 4, 6 and 7 during the course of the day. Who appears for the other respondents?
R8, my lord, state.
Who appears for 2, you appear?
2 is the appellant himself.
On the appellant.
That's right. No. See, you see the memo of parties.
Please, my lord.
It's in the name of the partnership and 2 individual capacity, he respondent number 2.
Yes.
Yes, sir.
Right?
Yes.
So who appears for him? Who appears for 5?
5, the dispensary with my lord.
6 and 7. And
My lord, yes, my lord.
8 is the state.
Okay. So 2 and 5 have been dispensed with.
Lord, 5 also on section 45 partnership act. He is liable to the consequences. It is paper publication of resolution.
In the course of the day, reply to the application we filed
But today it is not possible, please.
on or before 2nd of June.
Please.
Please.
Okay, list 1 minute.
Please.
List on 4th June. Okay, list on 4th June. And it will also file.
Please.
Your Lordship.
My lord.
Yes.
Lord, until the 24 hours there are many.
All right, Dr. Nagraj, we will look into it. We have to hear you on this.
Lord, with your Lordship's kind permission.
Yes.
I'm sorry, my Lord, serial number 13. Court hall number 7. I'm sorry.
We will now come back after lunch.
My Lord, I have a 2:30 matter. Please accommodate me till 2nd.
See, we will come back eventually. We'll just come back.
The number
959 212 331.
name
Vidyashri.
R 3
3, 4, 6, 7. ಒಂದು ನಿಮಿಷ ಬೇರೆ ಬೆಂಚ್ ಇದೆ, ಒಂದು ನಿಮಿಷ.
ನೀವು ಸ್ಟಾರ್ಟಿಂಗ್ ಹೇಳ್ಬೇಕು ಇಷ್ಟು ಬೇಕಾಗಿರ್ಲಿಲ್ಲ ಮೇಡಮ್ ಬೆಸ್ಟ್ ಆಫ್ ಮೈ ನಾಲೆಡ್ಜ್ ದೇ ಸಬ್ಮಿಟ್
Correct.
the contract to sell continue. Contract is to be cancelled, both has to agree. Unilaterally one cannot cancel voluntarily or arbitrarily.
Good afternoon, my lord.
Good afternoon, brother.
For pronouncement, Desh Pandey.
See, we have disposed of both the appeals. Please. By stating this. Having given a thoughtful consideration to the facts which arise for consideration, including the order dated 26/2/2019, has not been challenged by the respondent, we are of the view that the appropriate shall be the impugned order of the tribunal is set aside and the matter is remanded back to the Commissioner Appeals by granting liberty to the respondent to file its grounds of appeal against the order dated 26th of February 2019.
Please.
And upon such filing, Commissioner Appeal shall consider the issue of justifiability of the claim for refund when the customs duty to the extent of 1% handling charges has been deposited through self-assessment, keeping in view the applicability of the judgment in the case of Mafatlal Industries, Supra and Wipro Limited, Supra as the case may be, in the facts of this case and proceed to in accordance with law. Since we are remanding the matter to the Commissioner Appeals, the Commissioner Appeals shall also decide the issue of scope and effect of notification dated 26/9/2017 to the facts, keeping in view the judgment of the Supreme Court in the case of Wipro Limited and the law on the subject, and also the issue relatable to section 27 of the Act. The grounds of appeal shall be filed by the respondent within a period of 6 weeks from today, and the Commissioner Appeal shall decide the appeal in terms of this order within a period of 3 months after the expiry of 6 weeks as stated above. It goes without saying, upon passing of the order, the party shall be at liberty to seek such remedy as available in accordance with law. The appeals are disposed of.
All contentions to be kept open.
It's all kept. In fact, we have.
Because I have also cited some judgments, my lord, they also have a bearing. So
Yes.
I request,
Yes.
my lords, is because
We have left all the issues we'll argue so that all contention will be left open.
Yes.
Thank you.
I'm grateful. Thank you. Grateful.
Thank you, brother.
Thank you, my lord.
With your lordship's kindly, I have one request to make. Item 37 may be taken up after vacation any date. I have informed Shanti Bhushan, Deputy Solicitor General.
17-7.
I am grateful to my lords.
Serial number 23, my lords. Counsel for appeal. 3, my lords. Stage is for hearing, my lord. Any date after vacation may be given, my lord. Appellant, my lords.
21-7.
Much obliged.
Serial number 13, possible matter. Senior counsel asked me to take a date on Friday. Friday.
You mentioned before lunch.
Yes, my lord, you mentioned.
Please say.
Friday.
The deputy commissioner's order is very clear.
Tomorrow.
My lords, kindly.
13, sir. 1-3.
With the leave of the court. So I am mentioning one matter, a new matter for listing for tomorrow, please, my lords. It's a RERA appeal. It's fresh matter. There is a direction for me to hand over possession of the property, which was already been done. And my lords, there is a direction to pay the compensation. So my lords, the appellate, the authority, my lords, had rejected the complaint on the ground that it is not maintainable because the occupancy certificate was applied and obtained prior to, my lords, the rules were notified by the state government. So the complaint was not maintainable. Let's say it was applied in the month of January 2017. The rules were notified in October 2017. So the rules exempts those cases where the occupancy certificate has already been applied for. So the complaint was rejected on that ground. But the appellate authority reverses that finding and has allowed the appeal. It is being cleared. Very good. May I make one request? Your Lordship may say that subject to clearing of the obvious objection, it may be listed. Please, Manoj. That's the scrutiny. Sure. That's my only other difficulty is, Manoj, the office may not scrutinize it if at all it is not listed for tomorrow. It has been according to me. Please. Very good.
Make it till tomorrow.
Very good.
Make it tomorrow. Mention it tomorrow morning.
Very good. Please. I'll do that. Please. I'm great.
Next.
Serial number 20, Mr. Kumar M. Serial number 20.
Paper books are ready. My sequel Lord's indulgence, I file it.
Yes. Why are you giving it here?
Serial number 21, Mr. Manjuna.
For the appellant, I seek some time to file my reply to IA number 124.
deposit the entire equitable amount with interest on 4.24.
To that effect, I've made a affidavit on 29th August 2024, where a part amount has been paid to the respondent, that is to a tune of 53 lakhs melons. But thereafter, they have made an application for security deposit by filing an application. By an order of this honorable court, the property has been attached. It's now it is pending for hearing on IA number 1. I need to file my reply to that application. Vacating. I need to file my objections to IA number 1, that is vacating stay melons. They have made an application for early.
Getting stressed.
224 is filed by us for vacating the entry bond. On that application, we shall put a directed deposit the entire amount. Then thereafter we file one more application for entire direction. That is the application which now we want to file an objection, where detention is granted.
Just say that there was also for the seats that they were allowed for each to file for the petition being CU of 24.
Seven.
Oops.
Seven. Serial number 22.
My lord, kindly list after vacation, my lord.
Mr. Angadi.
My lord, senior as personal inconvenience, my lord.
Adjourned. 24.
I pay for the appellant.
24.
Appear for the appellants now. This appeal, my lord, is filed under section 37 against the judgment of the civil court under section 34, my lord. The civil court has set aside the order of the deputy commissioner enhancing the compensation under the National Highways Act. My lords would for a moment just see annexure B, which is the deputy commissioner's order, page 61, my lords. My lords has page 61. My lord, at the bottom of the page. This is the NH 206. On the left hand side, my lords, land acquired in Ramshettihalli. This is the appellant's land, which is for 3,956 guntas. On the other side, my lord, lands acquired in Edenahalli for 43,329 rupees, for 43,329 per gunta. On the basis of this, my lords, the deputy commissioner said that there's too much discrepancy between the amount awarded for the lands in Ramshettihalli and thereby awarded the amount of rupees 43,329. The district court, my lord, looks into this, accepts this. My lords will see the reasons. The reasons are provided at page 32 of the learned district court. My lord, that is actually the market value.
What are the reasons?
My lords, in the other village, that is in Edenahalli, but this is the amount that was awarded by the land acquisition officer.
That's right. What are the reasons?
But they say that it's on the basis of market value. No, my lord, those documents are not with me. Those documents are.
Other relevant considerations so far as awarding 43 that village. There can be special features which resulted in 43. Those features are not here.
These awards may have to be placed on record by me. These, please, the award may have to. If my lords could issue notice for, please. Yes.
As people from this perspective, that there is a similarity.
My lords may see.
No similarities.
Please, page 33, paragraph 25. Page 25, my lords. The third defendant at page 4 of the impugned arbitral award has held that the lands in Ramshetty village has been acquired for main carriageway, and the lands in Edenahalli village situated just opposite to Ramshetty village are acquired for formation of service road for the very same project, and yet different market value is determined by the third defendant, which is incorrect. The third defendant has also stated that he has conducted spot inspection along with the fourth defendant, surveyor and tahsildar. Thereafter felt the necessity of enhancing the compensation as requested by the defendant number 1 and 2. The defendant number 3 has further held that if there is a huge difference in market value while determining the compensation amount, there is provision for fixing a uniform rate for all the lands. The defendant number 3 has also treated the case as special case. There is no dispute with regard to Ramshettihalli village and Edenahalli village situated opposite side of NH 206. Then, my lords, at paragraph 27, if my lords would see the reasons for setting aside the order at page 36. Paragraph 27. Defendant number 1 and 2, though assailed the award of fourth defendant before the third defendant, and though contended before this court that the determination of the market value by the fourth defendant in accordance with law not placed sufficient materials in support of his contention. The defendant number 3, though enhanced the market value of the subject land from rupees 39 per square meters to rupees 428 per square meters, placing reliance upon the market value fixed by the fourth defendant in respect of Edenahalli village. As rightly pointed out by the plaintiff, he has neither narrated the facts in detail nor has ascertained the method adopted by the fourth defendant for determining the market value of subject lands, and has held that if there is a huge difference in market value, while determining the compensation amount, there is a provision for fixing a uniform rate. Therefore, my lords, it's not that the district judge has gone into what was being indicated by my lords. I will look at, I'll place those awards also on record. But what I have seen, my lord, is that it only in respect of market value. And if it is right opposite each other, please. Yes, my lord. Yes, my lord. So effectively what the learned district judge has said is that reasons have not been assigned, but not that there is actually a reason for this discrimination. It has not, there's no justification for the
Some reasons saying that these are the similarities. Without that, there can be some special features in that village which are not existing. So that depends upon the award of both the awards.
Please.
All the villages.
Please.
These were the relevant factors. And mind it, when it comes to the district level court.
Yes. Please.
You have an SLAO award. You
Yes.
have an arbitrator's award.
Yes.
What are the relevant considerations there?
Please.
There is a very interesting also 2534 NHAI.
Yes.
Challenging the arbitral award.
Please. Please.
That has been allowed.
Yes.
Set aside. No, and without giving any reasons. And finally, what did they do?
It's only set aside, my lord. If it was felt that there are no reasons, at least it ought to have been remanded before the But I don't have the option of working it out afresh. My lord, may just see page 49 for a moment. This is the order passed by the district judge. Page 49, my lords. The impugned award dated 25/1/2023 passed by the defendant number 3, the Deputy Commissioner and Arbitrator Tumkur, is hereby set aside. What is held by the learned district judge?
34 is set aside.
Yes.
Or allowed.
34 sets aside. Yes.
Which one is a tool? 34. There can't be any third eventuality. Generally, currently we once sense it back. It's fine. As long as
Please.
we have not exercised that discretion.
They have not. You have not.
If you.
Please.
So sum total of this order is, since there are no reasons, I am setting aside.
Yes.
That's in a way a prerequisite for an award to be a reasoned award. That's a requirement under the Act. He has not done it. Very well. If you are in law entitled to invoke the arbitration afresh, you will work it.
My lord, my request would be this. It's not that the award that has been passed by the arbitrator and the deputy commissioner is totally bereft of reasons. What he has looked at, that he says that the NHI is presently going through this. Both these lands lie on opposite sides of each other. The difference in the rates is very, very high. It is not some small difference even. My lord, may I just submit? The difference is the difference is very stark. And therefore, there is a need for uniformity, and it does that. Of course, as my lord says, we might have to look into the award that was passed. Yes, my lord, I do accept. In the award.
And those reasons are prevalent, are available here. So there cannot be any disparity. It should be the basis.
Please.
That's what we have to do.
Please.
Deal with more reasons.
Yes.
You like to invoke the arbitration and then go ahead.
My lord, I'll actually place on record those awards. I'll try to convince my lords, because if the matter is not remanded to the arbitrator, I might be put in a difficult position.
Now we are putting the connected way.
Yes.
What in 37 we can do? Can we say 34 court reasoning is not correct and set aside 34? That can't be. You are also accepting it. There are no reasons.
In 34, my lords.
In 34 or even in the award, arbitral award.
It is my respect.
No, the conclusion of the arbitral award by the 34 court that there are no reasons is justified. That's right. Can in 37 say the conclusion drawn by 34 is not correct on the face of it? Can we say so?
My lord, it's my respectful submission that the award of the arbitrator is not entirely bereft of reasons. If it was indeed completely bereft of reasons, I would see what my lord is saying.
Let's look on the sufficiencies of the reason. Whether saying that there is half the fruits and they are opposite just across the board would be a sufficient reason. Would be a sufficient, it can't be. We must go. What are the factors which weigh in that village, which are available here? This is something, this could be a very serious issue. This can be the basis for awarding a higher compensation, really, because that village has rational basis. These are the similarities needs to be seen. That's what we are putting in. Can we now in 37 say what he has done is wrong? We can't say so.
Please, my lords, I see what my lords is saying.
Possibly look into the law.
Please.
You will get it. The courts have said 54 would be only set aside or allowed, nothing more. You will get judgments.
Yes.
In such a scenario, see, you can't be precluded from seeking a remedy against your claims. If
Please.
In law, you are entitled to a higher claim compensation. You would do that. But this order doesn't give you the compensation. But it's set aside on a technicality, no reasons have been given.
Please.
But that technicality should not come in the way you will examine this.
Yes.
That technicality will not come in your way for you to invoke the arbitration afresh and then go ahead.
Please.
Limitation would not come because you are pursuing this remedy.
Please.
The 14 benefit would be there.
Please, my lords, I will look into it. Would my lords issue notice, because notice has not been issued to the other side? Very well, my lords. I'll look into it, my lord. I'll look into the same. Yes, there's an application. Petitioner number 2. I'm sorry, appellant number 2.
That is to bring the elders of respondent Kumaraya. That's right.
Yes.
Although the same is allowed. The aforesaid three legal representatives of Kumaraya are on record. Corrections be made in the amended memo parties, and the amended memo parties shall also be filed.
Grateful.
17(7). Serial number 25. Take over.
Yes.
Not serial number 25, 35 and 36 are the common order. Ma'am. Kindly take serial number 35. Serial number.
Yes.
Brief facts of the case are, my lord. These petitioners, 35, were appointed initially as LDS, lower division clerk in the remands. LDC, yes. Then, my lord, they are promoted to the post of UDC. UDC. In the year, my lord, 2013, Nimans amended the regulations. Amended the regulations, my lord, regulating promotion to the post of managers. Manager, which is a group B post. Under the Nimans Act, Lord, and the regulations, Lord, central government must approve. Lord, kindly see the A3 page 129, Lord, approval given by the central government. Manager is filled up, Lord, promotion 50% by promotion, 50% by competitive examination. Yes, Lord, 50% seniority, 5 years service in the Lord. On completion of 3 years. Yes, 3 years, complete 3 years. This regulation is not approved by the central government. Pursuant to that, Lord, limited examination, Lord, is held. Petitioners and respondents, Lord, 4 to 11 have taken up the examination several times. And promotions are given, they failed to in the examination. We are promoted to the post of manager the respondents, 4 to 11. That original applicants.
They were senior to me.
They are senior to me. Yes, Lord, they are senior. Admittedly, they are senior. I don't dispute that. But it is 50% within the competitive examination. On 18/5/23, we are promoted.
Was they promoted after they paid with the normal seniority?
No, no, they are not promoted. We are promoted.
Yes.
My lord will find A4, my lord, the circular is issued by the Nimans to fill up the post of 16 major posts, my lord, by conducting competitive examination. My lord will find page 136, all the applicants and petitioners are there in the list for competitive examination, limited competitive examination. But what they have questioned, my lord, in one application 11/5/2022 holding competitive examination 13/5/22 in one application 232 of 22. Is it not? First application 213 of 22. They have questioned the holding of competitive examination. That is 1 minute. Annexure A4 is questioned on the ground, my lord, that the regulations which is prior approval of the central government is not published in the official gazette. The original applicants 4 to 11. Association and one of the applicants questioned this in application number 239 of 2022. Annexure A4. Though they appeared for examination and not there. OA number 239 of 2022. But one more application, during the pendency of the application, 18/5/23 promotion order was issued to us. They have questioned the promotion order dated 18/5/23. Promotion order 18/5/2023. Yes, Lord, to the post of manager. This, both are clubbed together. Both are clubbed together. But application number 232 of 239/22, we are not parties. Application number 2, yes, we are not parties. We are not parties. We are not parties. You are not parties. Only the other application is concerned, Lord, we are parties because our promotions are questioned. The tribunal, Lord, Bangalore bench, interpreted the Lord order, stating that, Lord, though it is prior approved by the central government, it is not gazetted. Therefore, what the rule has not come into effect. Promotion orders are quashed. It has not been published in the gazette, official gazette. Official gazette. It is rule says what? Act says may. Kindly now take to the Nimans Act, which is there. I produced it first for providence. Yes, my lord. That's all. Large number of judgment, my lord, where it's the directory, my lord. Apart from that, my lord, regulation act says, my lord, only part 6 shall be published in the official gazette. Part 6 of the regulation, the rules. But I will show schedule. My lord, may kindly take the first the Nimans Act, my lord, page 226. 226. My lord will find the 233, section 31. Page 233, section 31. The institute with previous approval of the kindly note it, it contains 2 parts. The institute with previous approval of the central government, it is there. May by notification in the official gazette make regulations consistent with this act and the rules made thereunder to carry out the purpose of this act without prejudice to generality of the power of such regulations. May, my lord, I can understand, my lord knows, in the state of Karnataka Civil Service Act 1978 is there. How to promulgate the rule? Section 3 mandates, my lord, draft rules will be published in the Gazette, because it will be circulated among all the government servants. 15 days time will be given to them. Then, my lord, again, my lord, it will be published and gazetted in the Karnataka Gazette. No, my lord, kindly take the regulation also. Annexure G, my lord, page 230. Lord, we are working, Lord. Question is, Lord, we are working. Kindly stay our reversion.
Milord, I appear for the Niemans, Milord.
Mr. Rao, can we hear this?
Yes, Milord, I take notice for Niemans. Milord, this requires consideration. Reason is this, Milord. Neither the Act nor the rules and regulations of the Niemans Act have been amended. It is only recruitment rules have been amended with the prior approval of the governing body, and the governing body president is the.
What do you say on the official gazette?
It is not required for amended recruitment rules. Official
So
gazette
what is your stand?
Milord, amendment is required.
It is not required. It is not required.
Milord, this requires consideration. Tribunal has ignored this point and passed it to promotions. Milord.
Kindly take 302, Milord, the central government opinion also. 302 of the paper book.
Okay, now no, are you ready, or we want to look into that?
No, Milord, it requires consideration. Let me, the writ papers are given to me also, Milord, because they have served only Union of India. They have not served me. I am the necessary party to this proceeding.
Very well. Now, do you intend to revert them?
No, Milord, as of now, Milord, because of the tribunal's order, Milord, the promotions which have been given, it is there already.
Reverted, Milord.
You say?
It cannot be done, Milord, because it requires consideration. I am also challenging the tribunal's order. In fact, I have instructions to file the writ petitions, Milord. It requires consideration.
You are the person. You are the affected person. What do you say?
I'll take a lot to the legal conditions. That's at the state of.
Otherwise, it's a pure legal issue.
Purely. Can I just say?
But which are the judgments you are denying?
Right from ITC and PK Angar.
What is Bhadrachalam? ITC Bhadrachalam.
Can I just take a lot?
Milord, without going to the facts, Milord,
Vineet Agrawala is on the very point.
Milord, my submission
is a distinction between Vineet Agarwal and what Bhadrachalam is. In Bhadrachalam, ITC Bhadrachalam, without anything else, what the contention of Mr. Sorabji was that the approval of the cabinet is mandatory. Publication in the Gazette is only a ministerial act. Therefore, without it also, it takes effect. That, my lord, stood rejected by the Supreme Court. And that is what.
But I have one submission, man. When central government approved it, Lord, in the year 18, that has not been questioned.
Yes.
Unless, my lord, they question the, my lord, approval. Well, can they stop the promotion, my lord? Kindly appreciate this. Prior approval is there. That has not been questioned. His prayer must be, look here, central government approved it, which is not published in the Gazette. Please restrain them from implementing the rules till it is published in the official Gazette.
Oh, so you can't blow hot and cold. That's what he is arguing.
Yes, I'll just answer to that. I'm not on the question of interim prayer. There are two other factual points. There was a notification which was published calling for LDC examination. The moment that notification came out, 13/5/2022 the notification. 6/6/2022, we challenged the notification before the tribunal. One of the contentions is having participated, you can't possibly challenge the promotion.
No, the argument is the amendment or the earlier notification.
I'll just come to that. There was a notification issued, we challenged it. Tribunal said we will not state, let the process of promotion go on, then we will see. Process of promotion went on, they were promoted, we challenged it in the subsequent OA. Now, insofar as amendment to the cadre and recruitment rules, point out from the pleadings. Admitted case, even in the writ petition, their case is the central government writes a communication to NIMANS. It's a letter which is on record. Now, my lords, that letter is not published. That letter is not disclosed. That letter is not notified. On the basis of that letter, they say, my lord, we will conduct the recruitment to the post of manager by conducting LDC. Now, my lord, that letter, my lord, was not published until, my lord, we approached the tribunal. And after all, it was a communication, interdepartmental communication, which in the writ petition that my learned senior is referring to, they refer it as a communication. It is not an amendment. It is only a communication of the central government saying that we give our approval to your request to amend it. So it was not an amendment. That letter should have taken the form of an amendment. It never took the form of an amendment. So our case was, it can only be by way of promotion on the basis of seniority and not on the basis of LDC. Thirdly, publication in the official gazette is slightly different from publication. Publication in the official gazette, my lord, is statutory, whereas publication is mandatory. And that is what, my lord, even in ITC Bhadrachalam they had, that even if it is not mandatory, good conscience demands that it should be published to everybody who's going to be governed by these rules. Now, my lord, till today, neither NIMANS nor any person, my lord, came before the tribunal and said, this is the date on which we have notified. And that is all that was required. In fact, NIMANS said, we have not published it. They said, it is not required to be published, therefore we will not publish it. Now, my lord, my submission was, if it is a cadre and recruitment rule governing the candidates, then it ought to be published, if not in the official gazette.
Let's see the reasoning.
I just draw your lordship's attention to the impugned order. There is one other aspect, my lord, which I had challenged. Promotion was on 18/5/23 with effect from 1/1/23, retrospective promotion. I said there is no provision under any regulations for giving retrospective promotion, and retrospective, after all, is a statutory benefit. It can't be, my lord, in the absence of statutory regulations. Tribunal found favor with that also and said nobody has pointed out any regulations for retrospective promotion. And that is the reasoning at para 33.
Now, what is the effect from which the regulations were given effect to?
So grateful. That is not pointed out. The cadre and recruitment rules being relied upon is 2010. The NIMANS Act is 2012. The regulations are of 2013. So the effect of a subsequent act on an anterior recruitment rules, my lord, is something that your lordships will have to look into. Even otherwise, my lords, can I simplify this for your lordships?
Tell us one thing.
Yes.
These regulations or the regulations you may say not notified came in 2013.
Yes, 2013 it said sent to the approval, 18 approved.
18 it is approved.
And that comes into effect soon after the approval.
Tell us one thing, between 18 and 2023, so 18 was challenged in 23.
Yes, that is the only time, my lord, when we were called for promotion.
But there
Till
are
then I had no notification because I was never an aggrieved party. Your lordships will see, my lords, under 19 I have to be an aggrieved party.
How many LDCs have held between 2018 and 23?
2 or 3, my lord.
3 times, Lord. 3 times.
To which I was never notified.
1 minute.
My lord, may I also just draw today for
You are part of the system. You are part of the hierarchy.
No. I pointed that was also before the tribunal, and that is pending before your lordships.
That is not one cadre, my lord. 3 cadres.
1 minute.
That writ
Okay, now.
your lordships.
Okay, 1 minute. Let's not touch you. What will happen to the past one?
My lords, that yes, my lords, and tribunal has taken care of that. Tribunal has said, since only this recruitment is called in question, we are confining it only to this. My lords, may I just say this? In another writ petition where I am the petitioner and exactly same order is passed, only difference is that is a case of direct recruitment. Tribunal said we will not touch that recruitment, and therefore we deny you the relief. I came before your lordships, my lords, and your lordship said, having succeeded, you possibly could not have been denied relief. Now that is also pending before your lordships. In so far as interim prayer today, my lords, I don't know, my lords, as to why it's not placed on record. They are today managers. I am today a manager, my lords, by virtue of my seniority.
So by stalling their reversion, my lords, I can't go up possibly. Therefore, my lords, but the stay of the impugned order will result in their continuation in the seniority and further promotions. Though,
No, that's far-fetched. When you tell us what is the eligibility?
my lords, that is because of 3 years.
Next time.
3 years.
So 23.
Yes, my lord.
Not before 26.
No, 1123.
It's all right. Not before 1126.
Yes, my lord. Therefore, my lord, my only submission today before your lordships is this. My lord, your lordships might direct parties to maintain status quo. But if their candidature is to be taken into consideration for further promotion, it will be a case where, though I have succeeded before the tribunal, my lord, my promotion is not given effect to.
There is no cause for that, Mr. Pratish.
My lord, that's right.
We'll tell you. Promotion is subject to vacancies.
Yes.
Are there any vacancies?
Yes,
on
my
the
lord.
highest court? We'll look into it. We will. I think we can decide this.
My lord, that's right. That's my request, my lord. Interim order, my lord, is something that I'll leave it to your lordship. But
yeah, they'll maintain status quo. That's
my lord, may I make this request, my lord? My lord, let it not be taken as a order by which they will be further promoted if it is not heard in time.
If you feel they are being considered pendency of this litigation, you will come to the court.
May I make this? Your lordship may make it clear if any further consideration takes place. Let it be with the leave of your lordship.
Where is the cause we want to know?
My lord, that is because their seniority is maintained.
And do you expect that it will not be decided before?
My lord, I am not saying no, my lords, but after having known your lordship's board, my lord, my request is, in case it is not, your lordships may clarify with your lordship.
Mr. Pratish, you will come. Before that, when they are making it, you will come to the courts saying that stall it. The issue is pending. The issue is pending. And if they make promotion, you will be superseded. That's right.
My lord,
yes or no?
Yes, my lord.
No.
Now my
They will not be
seniority,
treated. They will appear for the competitive examination. Again, next higher cadre, 50% by competitive examination.
No, that's right. That's the problem, my lord. They will get promoted by virtue of 50% LDC.
No.
Mr. Bhagwat, what is he saying is,
it's imagination.
If your continuance is allowed on the post of manager, the next promotion post, you will get the eligibility.
Yes, and that is because of
That should be-
LDC.
But they are also promoted. They also will get promoted.
No, he gets promoted to the next cadre by virtue of LDC.
1 minute. Suppose suppose we don't give you stay. What is the effect?
Now that Nimans is saying they will not implement it.
Forget that. We don't give a stay and Nimans implement the order. What is the effect? You would be reverted. You would be reverted.
Yes.
And they will continue on the higher post.
Yes.
Because by virtue of seniority.
That's right. And you would not be entitled to be considered for further promotion from the post of manager. That's what he's saying is balance the equities, no reversion, but no further promotion till such time this petition is decided.
That's all.
That's what he's saying.
That's all.
My lord, one submission.
According to me, my lord, in Ranjini Singh, my lord knows the law. In the matter of interim prayer.
No, we will only say this.
Yes.
Status quo, going by what he is arguing, that any further promotion from the post of manager shall not be without the leave of the court.
So great.
We can say that. You will continue on the post of manager. Okay? But no further promotion on the basis of this status which is existing today. Getting the point?
My lord makes status quo. They can't do anything.
Okay. So your status quo means whatever your status is existing today will continue till the decision in the OA. That's all. Okay.
But
Notice.
that is not how Nimans understands it, my lord. Then again, I'll have to come.
1 minute. We will say status quo with regard to the position being held by the parties herein shall be maintained.
Yes.
That I think put quietus to everything.
That is one thing.
Issue notice.
My lord, I have one submission. My lord.
Issue notice. So and so accept notice for Mr. Pramod for Union of India.
Please, it's only in one matter.
One. Then Nimhans, Mr. Rao. 1, 2 and 3, Mr. Rao. 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Mr. Pitwish. That's right.
My lord, I will take notice only for 4, 5, 6, 7, and 8 months.
4 to 8, Mr.
4 to 8.
Prithvish, let notice be issued to other respondents.
Let other respondents, my learned friend is representing. Aditya, yes, he'll take notice for.
You appear for whom?
Notice to other respondents may be dispensed with.
Why?
Because they are similarly situated like.
The connected writ petition, they are petitioning.
Yes.
25 and 26, I appeal. Some of the applicants have preferred these writ petitions, my lords. The other batch, my lords, has preferred 35.
See, we have 9647.
They have 35.
Who appears in 9647?
Yes, but I appear for him, Mr. Aditya.
You appear for him?
Yes, yes.
So you are for the appellant, no?
Yes.
Now, who are for 9 to 14? Who is appearing for 9 to 14?
9 to 14. No. I think so.
Lords, I will take notice, my lords, for Christina Prince, which would be, my lords,
Christina Prince would be 12.
12.
Thereafter, my lords, Praveenesh, which is 13. And Tasneem Khanum, which will be 14.
14.
12, 13, 14.
Yes.
So and so accept notice for 12, 13, 14. Ma'am, this is 9647. Huh? Let notice be issued to 9, 10 and 11.
Huh?
Returnable on. Now, which is the other one? Other two matters?
25 and 36.
No, 35 and 36.
25, 35, 36.
35 is over.
35.
So we are on 25 now.
Yes, sir.
Who appears 25, Mr.
I appear, my lords.
Okay, now who, Union of India, Mr. Pramod?
No, my lord.
Mr. Unni Krishnan?
For respond number 1, my lord.
Okay. 2, 3, 4, Mr. Rao. 5, 6, 7, 8. Mr. Prithvish, you are appearing?
Please, ma'am.
5 to 9.
Yes, 5.
5 to 9, Mr. Prithvish.
That's all.
No, who appears for Nimhan's Employees Association?
Let the man, I undertake to file wakalat.
Mr. Prithvish appears for 4, 5, 6, 7, 8, 9.
Yes.
Okay. That's all?
Yes.
He states he shall file wakalat for respondent number 4 as well.
Yes.
Which is the other one, ma'am?
36.
36 leave is whatever.
25 leave is sorted.
25 leave.
25. IA for permission is filed.
Leave is.
It can be kept pending so that it will be up in the board.
IA, just notice on IA also.
Yes.
Which is IA number?
1.
Number 1.
IA number 1. So they were not the parties before the tribunal?
They were not.
That is challenging the notification. My application challenging the recruitment notification, which was published by Nimans. At that stage, they were not parties at all. They were parties in the order grant.
Stay application there in all the matters?
Yes. Writ petition, Lord.
All the matters?
Yes.
Interim stay, Lord, in the writ itself.
Then what about who appears in item number?
36. my lords, I appear.
Ma'am, this is 36? 36.
I take notice from.
1 minute, Mr.
One is
Mr. Who appears in this?
Unni Krishnan.
Unni Krishnan M, my lord.
Mr. Unni Krishnan for 1, 2, 3, 2 and 3, Mr. Rao.
4
What
to
about
9,
you?
I'll take notice.
4 to 9?
I'll take notice.
4 to 9, Mr. Prithvish. What about 10, 11, 12, 13?
But 12 and 13, Aditya Chakrigiri.
10, no, 9.
11, 12 and 13.
What about 9, 10?
Notice should go.
9, 10, 11, notice. 12 and 13? Just take his name.
Aditya Chakrigiri.
My lords, only 10 and 11. Please. 9, I believe.
Only 10 and 11. Notice.
9 you appear, Mr.
Yes,
Prithvish?
yes.
No minutes. 9 is Manjunath K. I don't appear. He's the respondent.
Then all.
Yeah, 9 and 10, notice, ma'am.
Yes.
11 and 12, his name. Where are your stay application? Having heard the learner counsel for the parties.
Interim
and
stay is not in the
peruse
writ petition.
It is directed that the respondents respondent Nimhans shall maintain status quo with regard to the post being held by the appellants / the individual respondents, petitioners and the individual respondents as existing today. That's right.
This one thing, right? One of the applicants before the tribunal, that is CGK, in the file that your lordships are holding, respondent number 8, she is yet to be promoted as manager in her in terms of her seniority. if your lordship were to direct status quo of respondents also, then she doesn't even get promoted as manager.
Then why has she filed? Why is she part of the petition?
Because she had filed in the OA, she has succeeded. She's
Who
yet
is
to
the-
get
what-
CG.
CGK.
Yes, she's yet to get promotion in terms of her seniority. If your lordship were to direct maintenance of seniority of respondents, then she doesn't even get promoted in terms of her own seniority also.
My lord, how it is possible?
No, appellant for individual appellants who are promoted.
But tell us one thing, has she been promoted as manager?
No, my lords. She's waiting for a turn in the order of seniority.
Not under LDC, under the promotion quota.
Promotion quota. We will not come in the way. We will not come in the way as per the
1
promotion.
minute, Mr. Bhagwat, let's hear him.
Your lordships are saying status quo of petitioner and respondents. But if that is the case, then what happens is this CGK, who is waiting for promotion in the order of seniority, does not get promoted as manager.
Why is she part of the petition?
Because she has approached the tribunal challenging their promotion.
Okay, full stop. This order shall not preclude the NIMHANS to promote any of the respondent.
Great.
Respondent who is working as SSA.
Yes, senior assistant.
Senior secretarial assistant.
Senior secretarial assistant to the post of
Manager.
manager
Yes.
under the seniority quota.
50% seniority quota.
Under 50% seniority quota.
Yes.
That's right. Okay.
I have one
Counsel for the parties to file their written submissions. I think it's a very detailed judgment of the tribunal. It dealt with
judgment.
many judgments also.
My lord, I have one submission.
Will the submissions be filed by the counsel for the parties? Re-notify the repetitions on. Mr. Rao, we have said so, status quo.
My lord, that is correct, my lord. I
PV.
agree with that, my lord. My lord, I have only one submission, my lord.
Yes.
The petitioners today, they have challenged on the ground that gazette notification is not required. My lord, even I am also contemplating to file the writ petition challenging the orders of the tribunal on the very same ground that the tribunal has erred in coming to the conclusion.
You want to file it?
Yes, I want to file.
You will file it, we will look into it.
Yes, my lord.
Because
We
in
have, additionally, we have said this, Mr. Rao,
Yes, my lord.
that whosoever has not been promoted to the post of manager,
Yes, my lord.
this order of status quo shall not come in the way for you to promote them to the post of manager.
Yes, my
Under
lord.
the seniority quota, if a person is entitled to the promotion, you will not deny them the promotion.
My lord, it is like this, my lord. What has happened, my lord? The petitioners who were there before the tribunal, my lord, they have not even successful candidates. But
Okay.
that was the
That's all.
trouble.
Thank you.
he is afraid of probably passing the same interim order in the petition to be, which will come before your lordship, probably.
Pardon?
They are also preparing writ petition. They may.
We will see it, Mr. Bhagwat, as and when it comes. Next.
24/7.
Grateful.
Yes. Let's see the next matter. 26 June.
Seal number 30. 30, Srimati Sunita Srinivas.
For the appellant, my lord, in this case, for the appellants in this case, my lord, in the last date of hearing, my lordship directed us to file the written submissions. It is not ready. Kindly have it after vacation, my lord.
23/7. Seal number 31.
Please, ma'am.
Shri Sachin BS. P1.
Please.
Yes.
It's appealed by the BD. Have no case, my lord, sir. Oh, my lord, so only, I have no case. Last location, my lord sir made it clear. Only I am on the part of interest. Interest part. Court has charged 10%. I'm saying that as per section 10% is awarded. I would, as per section 34 of CPC, reasonable interest. CPC says 6%.
Principal has been paid.
Principal is paid.
Oh, paid.
Principal amount is paid.
The health income also.
Being paid, the interest amount is paid.
How much has been paid?
First total entire interest amount, that is 41 lakhs 85,000.
And
Uh,
also.
Interest is calculated 10% per annum.
It's only for effectively 1 year and not even 1 year, less than 1 year.
Yes.
Oh, little,
Everything is paid. Principal amount is
how much you have paid?
whatever the order which is passed in the single judge order. Since the contempt proceedings was initiated and we have deposited the principal amount. We are paid it.
I want to be very clear.
My lords, I'm sorry.
You have paid them or you have deposited them, what have you done?
My lords, I'll make it very clear. We have taken a DD in their name and we had given it.
What do you say?
Paid at the principal. My lords, so we have got.
The payment to us. The payment has been made to us. That is 1,67,040. 67,040. We filed it. We filed an affidavit.
1 crore. 1 crore.
Sorry, 1 crore. Apologies. 1 crore 67,40,000.
Where is the affidavit filed for you?
My lord, we filed an affidavit on 14th.
My lords, on last occasion it was made clear while issuing notice that I should not press for other order, only insofar as interest is concerned. My lords has made it clear in the order sheet. Yes, sir. Lords, can I supply the proceedings in the contempt? Lords, court has recorded.
You have recorded your submission.
Yes, sir.
The state issued when this appeal only to the extent of
Interest. Lords, insofar as payment of amount is concerned. Payment ಆಗಿದೆ ಅಲ್ಲ? DD ಅವ್ರ ಹೆಸರು
Where do you say you can stay distance on the other part?
ಪೇಮೆಂಟ್ ಆಗಿದೆ DD ಅಲ್ಲಿ.
What about the other balance? 167,40,000. What is this 167?
My lords, kindly see page 17 of the writ petition order, which is part of record in a writ appeal.
Do we want to know?
Yes, sir.
How much you have paid? Does that satisfy the order of the single judge?
Whatever the amount as directed by the single judge, apart from interest, we have paid it.
Okay.
Yes.
How much? Okay. Then what about interest?
Interest we have not paid. We have not.
What do you say on interest?
The interest, they're supposed to pay us 22,09,360.
No, it's only on the quantum, 10%. It's only on the quantum. 10%, and that is only for the period between 421 to 522.
Period to dispute.
321 to
Period.
Period to dispute.
That's period also I'm not disputing.
How much according to you should be payable?
That's CPC section 34(6), 6%. 6%, section 34 of CPC.
How much is the banking interest?
Eh,
The every interest.
8.45.
Huh?
8.45. And my lords, I have got a decisions of the Apex Court. Lords, let me take addition of Apex Court. Apex Court said 9%.
How much? Is there any stipulation where you also charge interest? How much?
We charge,
What is say, man? Is there reduced interest?
I request to have this matter after vacation.
Little louder.
May I request for a date after vacation?
According to it is 22 lakhs.
interest.
No charges, PDK miscellaneous expenses, litigation expenses, 750.
So, it's the lower account.
Six percent. How much is the FD?
Please, man.
How much FD interest?
FD interest is 7%. 6.85.
Yes. Shall we say 7%?
I will have to seek instructions regarding. Can you have it tomorrow?
Who is the counsel?
Nishant.
Come tomorrow.
Please.
Let him be here. The request of counsel for the response.
29(4). 32 government advocate.
My lord, this is a state appeal. My lord, the learned single judge at page 13 has gone on a different, this is with regard to refund of monies paid at the time of executing the GPA, my lord. And the learned single judge at page 13, my lord, has relied on the case of creative aromatics specialities. Now, my humble submission is this would not be relevant to the current case, because the current case, we have two instruments over here. We have the GPA, which is executed in the year 2010, and subsequently a sale deed that comes to be executed in the year 2015. Now, if we look into the Stamp Act, that is Article 41EB, my lord. 41 deals with power of attorney, and the relevant provision that would be attracted to this particular circumstance of the case is 41EB. If I may just take your lordship through the provision.
What about sale deed?
Pardon me.
What about sale deed?
Sale deed is executed at, what about sale deed? Sale deed article, yes. Article 20. Article 20E. Now, the entire premise on which the respondent had come before the lordship is for refund of monies paid at the time of executing of the GPA. Now, GPA is a different instrument. Stamp duty at the 5 lakhs at the time of GPA, my lord. And at the time of the sale deed, it is 3 crore 35 lakhs.
5,80,500 rupees paid through GPA.
GPA. My lord, if I may take your lordship through the GPA provision which is attracted. Now over here, 41 EB, my lord. So 41 pertains to powers of attorney, and there are different circumstances under which power of attorney can be executed. Now, EB speaks about when given to a person other than father, mother, wife, husband, son, daughter, etc., in relation to the executant or authorizing such person to sell immovable property. Now, here we are talking about the respondent who is not at all related in any manner. If you look into the GPA, EB, my lord, which came into effect as of 1/3/2014. And if I can, the same duty, so the same duty as conveyance under Article 21 on the market value of the property, which is the subject matter of the power of attorney, provided that the duty paid on the agreement for sale under Article 5E, your lordship asked me which Article 5E, or an instrument of sale or transfer as the case may be, is adjustable towards the duty payable on such power of attorney under Article EB executed between the same parties and with respect to the same property. Now, the property may be the same, but the people, the executants are different in both these instruments is my humble submission. And therefore, the question of adjusting or refund does not arise. If you look into the GPA at page 26, my lord, page 26, Annexure A, we have Selvaraj and Ramesh Babu. Selvaraj, who claims to be the owner, and Ramesh Babu. Now, if we look into the sale deed, Selvaraj and Bhaskar giving the power of attorney to Ramesh Babu. Now, if we look into the sale deed at page 46, Annexure B, who are the parties in the sale deed? And this is in the year 2015. We have one Bhimsen Paul. Now, he claims to be the original landowner. And if we look into the covenants and the clauses under the sale deed, there appears to be that there was some fraud impersonated the identifying himself as Bhimsen. If we look at page 52 of the sale deed, my lord. And then we have Selvaraj and Bhimsen, all these together enter into a compromise, into a settlement, compromise. Amicable settlement. If you look into 52, the covenants, my lord, whereas an impersonator identifying himself as Sri Bhimsen, the vendor, sold the conveyed property so and so, so and so. Then we further look into 52 page, whereas on coming to know of the fictitious and fraudulent transaction of the actual owner being Bhimsen, Paul. And then the next covenant, whereas similarly Selvaraj, Bhaskar, so-and-so enter into an amicable settlement. So my humble submission is these are two different transactions, different parties, and therefore the question of adjustment does not arise. And the entire premise on which the learned single judge has gone ahead and dismissed the petition and directing the state to refund is misplaced. Because that the citation relied on by the learned single judge, my lord, was a totally different factual circumstance. And these are all fiscal matters. And each fiscal matter has to be looked into by the case, by each case, individual case, and the facts and circumstances. Now, creative aromatics, my lord, if I may furnish a copy of that judgment. Has no application, and I would like to rely on one judgment which is absolutely on this similar facts and circumstances. Oh, sorry. No, citation for that. Now, in this case also, my lord, this is a case of power of attorney given for executing of sale. Now, if we look into paragraph 5 onwards, just the arguments of the learned counsel for the respondent state, if I may read. On the other hand, the learned counsel for the respondent state of Karnataka has vehemently argued before the court that the learned single judge was justified in dismissing the writ petitions as amendment. The issue was also about whether the amendment is attracted or not in this particular case, and the same came into force with effect from 1/4/2011 as per the amendment proviso 41EB of the schedule. The stamp duty paid by on the GPA is adjustable on the sale deed executed only if the parties of the property contained in the GPAs and the sale deeds are one and the same. It is stated that the amendment came into force after the power of attorney was executed in the name of Mr. John Robert, etc. Therefore, the question of adjusting the amount paid on the GPA on the sale deed executed after 1/4/2011 does not arise. Therefore, the learned single judge was right in dismissing the writ petition. Over here, the learned single judge had dismissed it. Heard the learned counsel appearing for the parties at length and perused the records. The disputed questions make it very clear that the appellants have executed power of attorney and appointed John Robert as their attorney. 3 power of attorneys were registered on 25/3/2011, 28/2/2011, and 39/2010, which were the subject matter of the petition and connected with writ petitions. Undisputably, the power of attorney holder is not a family member of the appellants. The learned single judge has dismissed the writ petitions holding that the Karnataka Stamp Amendment Act 2011, which came into force with effect from 1/4/2011, is having retrospective effect. Paragraph 2122 the aforesaid order of the learned single judge is hereunder. The material on record clearly depicts that it is not a case of the petitioner in all the writ petitions that the GPA is executed in favor of the same parties, and the sale deeds are also executed in favor of the same parties. In the absence of the said pleadings, the impugned endorsement issued by respondent number 1 exercising power under proviso Article 41EB with effect from 1/4/2011 is just and proper. The petitioners have not made out a ground to interfere, etc., etc., and the petitions came to be dismissed. Then they've extracted Article 20, conveyance, Article 41EB, and then para 10 and 11, my lord, the aforesaid statutory provisions of law make it clear that whenever the GPA is executed in favor of a person other than the father, mother, wife, husband, sons, daughter, brother, sister, to sell immovable properties situated in the state of Karnataka, the stamp duty as conveyance under Article 21 of the market value of the property, which is subject matter of the power of attorney, has to be paid. And therefore, the stamp duty has rightly paid at the time of registration of the sale deed as power of attorney holder was not the family member, nor was within the relationship mentioned under Article 41EB of the Schedule of the Stamp Act. It is pertinent to note that the amendment of the Stamp Act came into force on 1/4/2011. The sale deed came to be executed subsequent to the amendment of the proviso, like in the current case. Hence, the stamp duty paid on the GPA is not adjustable on the sale deeds because the fact that the parties comprised in the GPA and the sale deeds are not one and the same. The duty paid is adjustable only in case where the parties are the same and the property is also the same. So therefore, my lord, the entire premise, and if we look into the, I had forwarded the judgment.
Which deeds have been compared to say that, the duty cannot be the same?
My lord, para 13, here also the appellants wanted refund of the stamp duty. The learned counsel for the appellants has also placed reliance on the judgment of Dalmia Cement so and so. In the aforesaid case, the judgment is again distinguishable on facts. There is no such issue involved. My lord? In which case, my lord? No, my entire argument, my lord, is GPA is a separate document and the sale deed is a separate document. Under the GPA, he paid 5 lakhs odd. Under the sale deed, he was required to pay 3 crore, etc. So he is seeking for adjustment or refund of the amount paid during the time of registering the GPA, that is 5 lakhs. My contention as the state is that these are two distinct instruments and it is not the same parties, and though it is the same property, and therefore the adjustment does not come into place. Refund, there is no question of refund in this case, is my humble submission. And these are fiscal matters. Please, my lord. There is no such issue involved with respect to applicability of Article 41EB or Article 21 of the Schedule to the Stamp Act. In the present case, the appellants wanted refund of the stamp duty on the ground that once the stamp duty has been paid while executing the GPA, the same should be refunded in view of the unamended provision. Any execution of sale made has to be done keeping in view the amendment which came into force on 1/4/2011. Undisputably, the sale deed has been executed after 1/4/2011. Therefore, the learned single judge was justified in dismissing the writ petitions. A reliance is also placed upon the judgment delivered in Mafatlal Industries, and the learned counsel has vehemently argued before the court that once it is established that the amount that is payable under the statute has been collected from the taxpayer and it is refundable, the taxpayer automatically gets a right to get paid the whole amount. If the right is sought to be effectively taken away by imposing conditions and later on a condition is imposed, then the condition has to be declared ultra vires the Constitution. The aforesaid judgment again is distinguishable on facts. As in the present case, the stamp duty has been collected, keeping in view the statutory provisions applicable on the date when the sale deeds were executed. It is undisputed that a fact that the GPA was registered on 25/3/2011 and the sale deed was executed on 16/5/2011. The amendment to Article 41EB of the Schedule to the Stamp Act came into force on 1/4/2011, and therefore the stamp duty was rightly being paid by the appellant's power of attorney holder. The respondent authority was justified in rejecting the application submitted by the appellant GPA holder in the peculiar facts and circumstances of the case. Therefore, this court does not find any reason to interfere with the order of the learned single judge. The appeal is dismissed.
Yes.
So these are fiscal matters, my lord, and we need to go. Documents.
There are two different
Parties, and therefore the question of adjusting and refund does not arise.
Now, my learned friend argue the new issues. That is not a reason you build order. Annexure F. Annexure F. That is the reason. Annexure F. What they have challenged before the learned single judge.
This is a different.
Correct. So, what is the endorsement I have challenged before the learned single judge? That is not a reason assigned in the respective officer. You have to kindly see annexure of page number 96. What is the reason he assigned? He said that he has relied upon the judgment of the Andhra Pradesh High Court. So in the Andhra Pradesh High Court, there is no provision to refund the excess amount. That is agreed. So in the Karnataka State Amendment, State Act, there is a provision. I will show you. That is the reason.
Where is the charging section? Where is the section which says refund can be made?
Kindly
What
see.
circumstances?
Kindly see. That is 44 subclass 2.
Okay. Sure.
The matter is already covered. There is a division judgment. There is already 3 judgments for covered this issue. 44 surplus 2. Power to revenue authority to refund penalty or excess duty in certain cases. Where any penalty is paid under section 34 or section 39, the chief controlling revenue authority may, upon application in writing, made it in 1 year from the date of the payment, refund such penalty wholly or in part. Under this provision, you made an application before the district registrar. District registrar will show, refuse my application on the ground. There is no provision under the act.
My lord,
What is the occasion to seek the refund?
Refund ownership. Earlier occasion ownership, they are given a power of attorney. In the power of attorney is already hand over the position of the property, same property. Then you get into registration of the sale deed. In the registration of the sale deed, by oversight, you will pay the excess amount. Your earlier occasion, when the ownership they are already hand over the position, they have to set up the 5 lakhs rupees. Power of attorney to registration, you only ownership 2,000 rupees. Excess, you are already paid 5 lakhs rupees. Just you requested authority, please set up this amount with the stamp duty.
How much was otherwise the payable in GPA?
Total you paid 5,80,000 rupees.
5,80,000
and add.
Okay. This you wanted to take it back?
Yes,
because sale deed has been executed.
Sale deed executed because parties are same. My learned friend same. That is one party is different. He is not necessary party. However, is included because he also sale agreement holder. Just his sale agreement. Parties are same. The property is same. Identical circumstances. You should dishonorable court. You should kindly see.
But how would you answer this 41(2)(b)?
and in fact, even 44, my lord, the section relied on, it speaks about excess duty. This is not a question of excess duty. These are two independent documents. And therefore, the question of excess duty comes if on a sale deed, if he has paid some amount and then paid subsequently excess amount, like in the case of creative aromatic specialty, which has been relied on. In that, it was a matter of excess duty paid on the same sale document, sale deed. This is not a case of excess duty at all.
This issue already covered by the judgment of dishonorable court.
Yeah,
and they are already accepted.
How much is the amount sought refund?
5,80,000 rupees. That is only small amount. The petitioner is a complaint, the respondent is a practicing advocate. He paid the excess amount. This issue, should kindly see, identical issue. And
this is the same, which is
this judgment a single judge order, but this judgment is upheld by the re-judgment. I will also going to lay upon this judgment.
My lord, the facts and circumstances of this case is totally.
Purchased a subject property on 31/5 from the GRP operational control system in private. While registering the document of sale, stamp duty was paid on sum of which was sales consideration, and petitioner was paid sum of rupees stamp duty. Instead of petitioner paid the stamp duty. This was excess was paid. The petitioner taken the main application under section stamp duty seeking a refund of excess stamp duty that is paid. The respond number in the terms of the recommendation dated so clarified the entire position and communicate to the respondent holding that the petitioner is not entitled to refund of stamp duty in terms of section 42 subclass 2, he also officer is rely upon same cells in your refugee payment. The respondent number 1 reject the application without even making a reference to section 42 subclass 2 of the Stamp Act, but relying upon the judgment of the Andhra Pradesh High Court, holding that the stamp duty paid by the mistake cannot be refunded under section 45 subclass 2 of the Act as the petitioner voluntarily made it a said payment. It was identical set of fact. The learned officer has given the same reason in my case. It is rejection of the direct petition, this court subject petition. Ultimately, the learned single judge rely upon all the provisions. You should direct it to refund the excess stamp duty, and this judgment is upheld by the
Para 9 of the judgment, my lord. Para 9 speaks about how it has been wrongly calculated, the amount which stamp duty to be payable on the sale. Para 9 of the judgment.
And this judgment is upheld by the division bench of
Here there is a finding, it's a clear finding, that he had actually paid excess. Instead of 33 lakhs, he paid 74.
In my case also, I had paid the excess amount.
That's one aspect of it. The second aspect of the case is that the parties to both the instruments are different.
No, Your Worship, my case is parties are same. Only one party is different because Your Worship, he has entered a sale agreement. He is not a owner of the property. He has entered a sale agreement. He has included the sale deed. Your Worship, both two parties are.
Section 41 is between the, you see that section.
We make request for this. By having one amended act, Your Worship.
Good luck.
See, the intent is this, within the family members, permissible.
No, Your Worship, there is one, they are also rely upon one judgment, Your Worship, they are quoted one judgment. The power of attorney, plaintiff already paid the amount of consideration amount pursuant to agreement of sale before executing the power of attorney. Power of attorney not given the consideration. The imposition of the stamp duty and penalty held illegal. That's one more judgment, Your Worship, I will rely upon this judgment also. 2008.
What is the date of execution of the conveyance deeds?
My lord, the GPA is of the year 29/11/2010, that is Annexure A, and the sale deed is 29/9/2015, Annexure B 46.
2010, Your Worship, the power of attorney. 2015 is the sale deed, absolute sale deed.
That's what I said.
So this agreement was in place.
Yes, that's what, 2014. And this is 2015.
2010 and 2015.
Please.
Before
So,
amendment-
and the representation comes to be made at Annexure C for the first time at 1/10/2016, after a year, almost.
But
No, a year.
It's only the sale deed, execution of sale deed triggered the refund date.
Please, that is in the year 2015. So firstly, it is struck by 41 EB. Secondly, the conduct of the respondent herein of approaching the authority after a year for refund itself questions his bona fides.
2010, there is no amendment.
And the
there is no
rejection-
amendment. Your Worship, the 2000 after the Your Worship, the amendment is only taken place after 2014. So So that is the reason why the amendment of is not applicable.
And the amendment is perspective actually, since to.
It's a 1999.
Inserted by Act 2012 with effect from 2001-4-2012.
How is this applicable?
1-4-2012 was prior to the sale deed. Sale deed comes on 29-9-2015. EB, please. Oh, sorry, sir. 1-4-2011 actually. Proviso substituted by Act number 19 of 2014. Ah, 99, but I'm talking about the proviso, my lord. 99 is with regard to other than mother, daughter, wife, etc. The proviso, wherein it says, provided that the duty paid on the agreement for sale under Article 5E, it has to be the same document between the same parties. That came about, that proviso came to be brought about in the year 2014 with effect from 1-3-2014.
Respect agreement sale. This is not agreement sale here. This is the power of attorney.
No, power of attorney and the agreement of sale. The proviso takes into account any kind of agreement for sale under Article 5E or instrument of sale or transfer as the case may be. So GPA executed in such circumstances.
Yeah, would you answer, even if there is a 140 rule additional in the sale deed, this rule will come into it.
Please.
The intent appeals to be supposed to what A and B executed, there was a power of attorney. Then a sale deed happens between A and B. It's only that whatever is the stamp duty for power of attorney will be paid back.
No, that is the power of attorney. I have to pay only 1,000 rupees for registration of the sale deed. Registration of the sale deed, power of attorney. But by mistake, I paid the excess of both.
That's what we are asking you. It's only in a case where the parties are saying, the change in party, what is the effect thereof? Are you saying you have paid excess? You paid excess? What
The question.
power of attorney stamp duty?
That is only 2,000 rupees.
That's all.
That point of time.
So why did you pay 5 lakhs?
That is extra amount, excess amount.
Now that is in the year 2010. He claims to have paid excess. Then if he has paid excess, he should have made a representation at that point of time. Now under fiscal legislation, my humble submission is, we got to go stricto sensu as per the provisions of law. Please.
In this factual scenario, 2010-2015, when he is entitled to make a request for refund, tell us.
He has made a request.
Don't go by this.
Right.
Law. It says 1 year.
Yes.
It
Yes.
says 1
Yes.
year,
Yes.
24.
1 year he has to make the request if it is excess.
Only 1 year will start only 2015. What is the triggering point for refund? Once there is a GPA, second there is a sale deed between the same parties, that the GPA amount he will seek refund.
Refund.
See, this case is also possibly. This case is for GPA also he paid excess.
Now, my humble submission is, if he has paid excess at the time of execution of the GPA, then he should have made a representation to the department or the registrar at the relevant point of time to say, I have paid excess.
Is it your case that because GPA was executed first and then sale deed, you are seeking the refund, or since you have paid excess stamp duty at the time of GPA only, you are seeking the refund?
First one.
Which one? Because of the sale deed? Why do you say because of the sale deed you should be seeking the refund? what is the feature or what is the reason for execution of a sale deed? You are seeking the excess amount, the refund of the stamp duty. Are you saying that since there is a power of attorney accompanied by the possession of the property, leading to the execution of the sale deed, where in the power of attorney also you find a stamp, paid a stamp duty, and even the sale deed also paid a stamp duty. The stamp duty which you have paid for the GPA, you are entitled to the refund. Are you saying you are entitled to the complete refund?
Yes, sir. Excess amount is I am entitled. After deduction the 2,000 rupees, I am entitled.
So minus 2,000, you should be. So if that be so, then you are only claiming the excess amount you paid in the GPA.
Correct.
Not on the basis of sale deed. If you are seeking on the basis of sale deed, will you not seek the refund of the complete GPA amount, GPA stamp duty?
No, I am not seeking.
No, will you not be entitled to claim the complete stamp duty?
I am only entitled to pay only the 2,000 rupees. The remaining amount I am entitled for
So
refund.
that means I have paid excess about 2,000, maybe wrongly, erroneously, that should be returned back. If that be so, how would you answer this 1 year limitation?
So that is not mandatory. May, that is their legislature use the word as may.
Okay.
Yes, sir. 10 years should be 45(2).
So even 10 years, 20 years, 30 years, 40 years.
So there is no mandatory provision.
Right. The intent would be there has to be, the person must express himself at the earliest. See where penalty is paid under section 34, 39, may, upon application in writing made within 1 year, from the date of payment, refund. The refund is discretionary. It's like, when the court fee act, when the court fee is sought to be refunded.
That is discretion of the court.
You read that provision once again. Read it.
44 the plus 2, where any penalty is paid under.
See one first.
Where
Where any penalty is paid under 34 and 39,
the chief
authority may, upon application in writing within a period of
1 year
from the date of payment, refund such penalty wholly or in part. See, the may has to be read in conjunction to wholly or in part. He has a discretion to give complete or in part. It must be read in conjunction with this, but not in the conjunction or not to be read that the person who is seeking a refund, he can come anytime. It is a limitation of 1 year there.
Get back to this issue, Rashad, not. I'll get back to this issue.
Right? We are also considering the first time. Surely for me, it is the first time. Where is the opinion of the chief? We now see in excess of what is legally chargeable has been charged and paid under this. Such authority may, upon application, have been made within 6 months of the date of registration of the instrument. This is in the case of a registered instrument.
Yes.
Was GPA registered?
Registered, my lord. Registered.
Then it would be 6 months.
So if he is asking
44(1) deals with
penalty and 44(2) is the excess amount. Please.
44(2) excess amount.
Provided that with the sanction of the state government, the state controlling revenue authority may refund. So there also there is a high.
This is only under the stamp act, there is a penalty. Insufficiently stamped.
Yes, yes.
Not stamped at
Yes,
all.
yes, yes, yes.
10 times.
Yes.
But you should kindly see wording selection 44. Both to revenue authority to refund penalty or excess duty in certain cases.
So both penalty is 44(1), 44(2) is the excess. So now read where in the opinion of the chief controlling authority stand to be in excess of what is legally chargeable has been charged and paid under any other provision, such authority may upon application in writing made within 6 months from the date of registration of the instrument or the order charging the same. There is a limitation here 6 months, not even 1 year.
I will get back with research.
Look at it. Well, this is
My lord, I
44-2.
I'll get back with research.
Not penalty 44-1.
My lord, there is a stay that I have application for stay. Yes, there is a contempt.
I'm not pursuing the issue. Anyway, contempt is also tying with Alan.
It's all right. Just looking to that.
There is a stay of the learned single judge's order and a delay.
When the contempt is here only.
Yes.
And he is also saying.
No, the issue
I'm not
is.
pressing English. I'm not going to press English for the law.
No, the issue is based on the learned single judge's order, various anomalies are occurring wherein they are asking for refund and all, and this will create a financial.
How many cases of that nature have come to you?
My lord, I have been instructed that there are a floodgate of cases, and therefore I am insisting on the stay of the learned single judge's order. Because these are fiscal matters, my lord, and
It's all right. Also, we can record his statement also that would really suffice the purpose. The matter is
please, an order may be.
I'm not pursuing the contempt petition. Anyway, matters child with along with the writ appeal.
concern is different. So based on this, many other cases are coming.
No, there are other matters, not similar matters. There are other matters. Already the disseminate, they are accepted the judgment. Respect to other matters, they are already filed SLP obtained.
No, that is a totally different issue where they are talking about excess payment. Now, my issue is over here, excess payment also he is not entitled, and refund also he is not entitled. Excess, why is he not entitled? Because he hasn't come within the stipulated time. Refund, why he is not entitled, and he has not made an application within the required time. Refund, why he is not entitled? Because they are not the same parties. So on both grounds, he is not entitled for any kind of refund, is my humble submission. And my humble submission is, if the stay or some kind of order please.
Are you saying based on this sort of people are coming to you?
The learned single judge's order.
Based on that?
Yes.
Where do you say your stay application?
I haven't stated in my stay application, but these are things that have come about after the order of the learned single judge and the filing of the writ appeal, my lord. This, because while I was getting.
I want to say one thing. Whatever my lineage argued before this conference, that is not a part of pleadings. That is entire thing is new issue. Kindly see writ appeal also.
But
it's a pure question of law.
law.
It's a pure question of law.
I agree.
Unless there is a factual scenario.
Yes, yes.
For the facts, like whether the parties are saying.
They are not taking the contention in pleading. That is also factual aspect.
And then we are with you on that. If such a plea is being taken, if no plea has been taken, we can't even look at it. Well, it's a factual.
Factual. They are not taking that kind of contention.
The document speaks for itself.
But your case is you have applied beyond 6 months. That's point and 42. We will do only one thing, we will stay the contempt. We will record his submission.
Please.
If you get anything, then you must say so in your application.
No, I am not pursuing the contempt.
Stay of the learned single judge's order.
No, we are only saying contempt is, he is not pressing the contempt. If you are saying that on the basis of the single judge you are getting, you will file a fresh application. Getting the point? And you must say so. You should know, na? Otherwise, this is inter se parties.
My lord, but the learned single judge's order has gone on a different premise altogether. It has gone on a case which can, the factual circumstances totally different. So therefore, my humble submission is, contempt is a different issue, my lord.
An interesting thing,
They are relying on this judgment.
Just say, where your stay application, let's see your stay application.
I for stay at page 108, my lord.
Where are your grounds in the
Writ appeal grounds. My writ appeal grounds are not.
Where are the grounds which is beyond 6 months? Where are the grounds the parties are not saying that's a pure?
My lord, I'm just going by the law. However, when you we look into the grounds,
There is no single
my point number 10 at page 10, the learned single judge ought to have held that the character of the documents that were presented for registration are not identical and that of the referred case, and hence should have passed an order independent on the merits of the present case. So based on this ground and the law, and then 11 also, para 11, that it is evident from the recitals of the writ petition that the first document registered by the respondent was a GPA. The learned single judge ought to have held that since both the documents are different, the nature and character referred order of the coordinate bench is not applicable to the facts and circumstances of the case.
Say this specific stay application by Stuti that there is your point for limitation is beyond 6 months.
My IA for delay.
That is not taken.
Paragraph 13.
The learned single judge ought to have held that there is no violation of 44(2).
They are not.
Submit.
That is again different, my lord. There has been. Yes, I did. I did see the stay application at.
That is not connected to this issue.
Yes, that
They have
is.
taken the judgment.
Transfer of development rights. That is
Not in
different.
respect of this issue.
I have actually filed a memo. That is with regard to Article 27, my lord, and that is totally different from this current fact situation of the case. I only would suffice to.
That the lender had allowing the reputation and the character of document that was collected for registration are not identical to that of the rendered case. You should not have passed another independently and should have passed the order independently of the rules of the present case. But it is the submission that this lender ought to have held that since both the documents are different in nature and character, the record author of the document further states that in any case, the question of the applicability of 44(2) the section 44(2) of this Karnataka Stamp Act clearly mandates that the excess of stamp duty can be the refund of the excess stamp duty can be made by filing an application within 6 months from the date of registration of the instrument. In this case, the amount, the excess of stamp duty is being paid on the GPA, on the stamp duty paid on the GPA in the year 2010, whereas the application for refund has been filed in the year 2016. Hence, much beyond the time contemplated under this section. Though a contempt to the counsel for the respondent state that the contempt should not be placed on the witness of things, not be deemed to appropriate to state the operation of the order passed by the witness, whether the patient selection and repetition of the service till the next date of the counsel for the parties to file their note of submissions along with the judgment they want to rely on.
I request for you to kindly see page number 14, like order of the learned single judge. They are considering before the learned single judge. They are not objected to dispose the matter. Which page? Page number 14. Order of learned single judge. They straight away concede. They are not raised this question of law before the learned single judge.
We hadn't filed our objections also before the learned single judge, my lord.
Page number 14, you should kindly see. They are not objected before learned single. The law is not applicable. Facts are different. They are not objected before learned single judge. First time they are saying that the law is not applicable.
My lord, that doesn't.
Conceding means they are not objected before learned single judge.
This is the order of the learned single judge saying that this is covered by the judgment.
But they are not objected. When the matter is disposed before the learned single judge, they say that the judgment is not applicable. This is the first time they are saying that.
When the court is forming opinion that this is covered by this, there is the objection.
At least they have to say before the court, the law is not applicable, the facts are different, law is different.
Have they filed objections?
No, we haven't. No, we haven't filed. In fact, I have filed my memo stating that we haven't filed.
In such a matter, you should file an objection.
Please, my lord, we should, but most likely the state always loses. Most likely the state always loses most of its matters against private individuals. So
17(6).
Much obliged, my lord.
Seal number 33.
Respondent not to any statement of objection. 33, none. 143, writ appeal. 33. 33.
33.
I am for the petitioner here. This is for one of the member of the society is asked for the allotment of site.
Allotment of alternate site.
What do you say?
My only prayer regarding if any future layout has been formed, he is entitled for the
You are the respondent?
Yes.
What do you say?
Because no sites is available.
Let's ask.
Seeking for a short time, we
The joint register and the tribunal order is in favor of the respondent, my lord, with regard.
Request of counsel for the respondent number 1. I mean, looking for. Next.
77. Serial number 34. 34, Sri Ramesh.
This is answering for the appellant. The respondent number 4 has filed statement of objection, same not yet served to.
Government notification.
34.
That's it for the respondent in this case.
Yeah, 34 ಅಲ್ಲ. ಇಲ್ಲ, writ appeal ಇದು.
Objection file ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು. Respondent number 4 objection filed ಅಂತ.
34 objection.
34.
I appear for respondent number 4 in this case.
Now the representation made was there was no power of attorney given to that gentleman. What is his name? Yeah.
Anantamurthy.
Who has to answer this?
Respondent number 4 ಮೇಲೆ.
For respondent, who had to file objections?
I have filed objections to the IA only, my lord. So far as that aspect is concerned,
That hasn't been served on any of them.
They are not served copy.
Now
Kill a
tell
person.
us, did your father?
Yes, ma'am.
Did your
Yes.
has earlier filed a writ petition?
No, my lord, you are not filed.
See the reply filed by the.
yes, my
No,
lord.
they have not said served the.
Anyway, I'll give it now. Yesterday, I sent it by registered post, you might not have received. I will give it a copy, give you a copy now.
No, my lord, not yet filed.
and latches itself, please, not.
All of you will file your replies. The others also, we want those corporation rules also. And just give a copy to him, please.
ಕೊಡ್ತೀನಿ, I will give it now.
Just give it now, you will file it.
Yes, my lord. Yes, ma'am.
ಆಮೇಲೆ, so far as I have filed objections only to the application, my lord. So far as the writ petition is concerned, there was no occasion for us to file the written statement. No, it may require, no, certain more contentions are urged in the writ petition. I have not answered those contents. Yes, ma'am, I shall do it, ma'am. One of 24, ma'am.
Also file their objections to the writ appeal. The copy of the reply as filed by the respondent number 4 to IA number 1 of 24 has been given to the counsel of the appellant.
Yes, ma'am.
ಕೊಟ್ಟಿದ್ದೀನಿ.
Appellant who shall also file rejoinder to the same.
Yes, ma'am.
Copy of the IA has to be served on me. Copy of the IA has not.
No, along with the appeal memo ಬಂದಿದೆ ನೋಡಿ.
ಬಂದಿದೆ.
ಬಂದಿಲ್ವಾ? ಸರಿ.
This down.
23/7.
ಎಷ್ಟು ಡೇಟ್ ಎಷ್ಟು ಮೇಡಮ್?
23/7, sir.
23/7.
38.
Please, Your Lordship, I represent the.
Serial number 38.
Lords, I represent the respondent in this minutes.
Yes.
Lords, it's a 37 for final hearing, my lords. We have filed our written submissions, note and judgments.
Who appears for the appellant?
Sri Raghuram Kadambi.
I appear for the appellants, my lords, in this matter.
Yes.
I appear, my lords, I seek adjournment.
My lords, I represent the respondent, Your Lordships. This matter is being delayed by the appellant, my lords, for no reason, my lords. Now, in the the appeal is being delayed by the appellants, my lords.
We have seen that last.
Many adjournments have been sought.
Hold on,
on
my
the
lord.
ground of,
Read by Mr.
learned
Nandakumar.
Solicitor General.
Just 1 minute.
Sorry, my lord.
You have taken adjournments on the previous occasions also. So we are, as a last opportunity, we will say so.
Grateful, my lord.
Just say that further adjournment, once again, adjournment is sought by the counsel for the appellant. As a request for the last time, the matter is adjourned to. Next.
Lordships may kindly give a fixed date, my lords.
We are fixing a date.
14/7.
That's the interim order, madam.
Interim order, if any, to continue.
Great.
My lords, can it be 16th, my lords, instead of 14th, my lords?
16th.
So grateful, my lords.
38, 39. Serial number 39.
Say none for the parties adjourned to.
31/9, 31/7. Serial number 40.
Not serial number 40, my lord.
Appeal for respondent number 4.
Lord, Legal Services Authority has entrusted the matter to me. Lord, my name may be shown, my lord. My name is not shown. Srimati Sumana Hegde's name is shown, my lord.
Legal services. Now you are for the petitioner here.
Yes, my lord.
Just say this, the name of
Satish K, my lord.
Mr. Satish K be shown in place of Ms. Suman Hegde.
Please.
As a counsel for the petitioner. Just re-notify on.
24/7.
Next.
Serial number 41.
Affair for the appellant in this case. And this is a short matter wherein sought for a mandamus to issue the kata in respect of the sites belonging to the appellant society.
Just say that re-notify, just give it in June, last second or third week.
24/6.
Next.
24/6, madam.
42.
Hearing for the appellant, section 37 appeal. There are 4 appeals that are pending. Will be taken up immediately after vacations.
Just say re-notify these appeals on. How long you would take? This would
Maybe
take time.
Maybe about an hour or hour and a half.
In all the appeals?
Yes.
Just do one thing, give a date, time also will give. Give it in July at 2:30. We'll have it at 2:30.
14/7.
Who is opposing you?
Dua associate.
Okay.
14/7.
I'll inform.
44.
Hearing for the appellant in this matter also. Will be notified after vacation.
Just say re-notify only. Just give it July only, no time.
28/7. 46. 46.
Appellant, my lord. Land grant order has been challenged in this, my lord.
Just say, we'll re-notify it.
Or date may be given.
At the request of counsel for the appellant, give a date in July. Next. See, this is 46 now. But this is, he said, goes to civil court. What is wrong in that order? And there are disputed facts.
May be kept after vacation, my lord, sir.
Okay, just give it, ma'am, July. Next.
14/7. 47. Shri Pradeep.
For appellant, my lords, I pray for short accommodation, my lords.
You are for whom, ma'am?
Appellant, my lords. Municipality, my lords.
Just say re-notify.
My lords.
327.
Interim order, my lords.
Interim order, if any. Pardon?
Shorter date may be given, my lord, any day in June.
They will just give it in 3rd or 4th week.
23/6.
Next.
48.
I'm for the respondent, Your Honor. My case is very critical.
Appellant.
After retirement, I have been dismissed from service just to deny all the benefits. 60 lakhs has been withheld. Pension, gratuity, nothing is being paid.
Where were you working?
HL.
Where were you working?
I was working in HL as a senior.
Okay.
And 30th, July 22 retired. 15th July dismissed from my chairman in his last 3 months of working. So many violations. I am not going to touch any of the inquiry matter. Only the violations. 7 violations are there. He has sat as a judge of his own cause, and he had his own assistants to conduct the inquiry. He did not bother to see what has happened in the thing. He did not call and talk to me what has happened. And we gave the complaint to police. Police said it's a matter is civil in nature, go to court. He did not go to court. They did not, except to punish me, nothing else was there. Because anonymous petitions have gone to ministry, they asked them, they made some violation. For promotion, 3 years, 2 years should be there for service. He had reduced it to 1 year to accommodate somebody. That somebody has written an anonymous petition to ministry. For that he is charging because my IP has been used. My IP anybody can use because the entire company knows the thing, including HL IP has been intervened by somebody and they cheated 40 lakhs.
What is the charge? Charge is only this on promotion?
No, my lords. Charges are pretty grave, my lord, if my lords may see. It's with respect to carrying, he was found, like his car was found with certain CDs of obscene content, containing obscene content. And in fact, there were certain letters that were raised to the ministry because saying against his own organization being at a very higher position, my lord. And those were the several charges which is also been barred by the service rules, my lord.
I have been given a chauffeur-driven car. Company has planted the CDs in the car in the evening. Morning, there's the CDs are there in your car. And the order has been given in my
Full-fledged
favor.
inquiry has been conducted, requires detailed hearing.
Actually, order has been given in my favor. 1 year, they are not come for arguments.
Inquiry report is there on record?
Please, my lords.
Everything?
Everything is there on record. In fact, our list of authorities is also there.
Just give it in June, man. Just re-notify.
May kindly consider 4th June, Your Honor. I'm waiting for last 12 months without any facilities and struggling for things, and they're deliberately torturing me.
4th June.
Much obliged, Your Honor. In the afternoon, if you permit, much obliged. Because I can make a submit. Only 10 minutes is required, not beyond that.
10 minutes, you don't require 2:30 then. Here in the morning.
Okay, Your Honor. Much obliged, Your Honor.
Obliged.
Yes, Mr. Ola, here you cleared? Cleared?
Yes.
Tomorrow. Is there any caveator?
No, there's no.
No caveat?
No.
Tomorrow.
Past over matters, number 4.
May I request?
I know.
Tomorrow, Your Lordship, I'll take my chances.
Best case.
Best case, Your Lordship, is that the detention order is passed. The detention order which has been passed does not have a live and proximate link. The crimes which have been referred to in the detention order have no live and proximate link to the exercise of powers under Section 2G. That's the best case. And about 167 days from the date of the last crime, there is no reason forthcoming in the detention order. 22nd August 2024, there is an 18th August 2024, there's an allegation against me that I assaulted someone. I've been let out on station bail in that matter. Then after that, there is no criminal. The other cases, except for there are 12 cases which have been registered against me, Your Lordship. 8 of them are more than 2 to 3 years old. Insofar as the other 3 cases are concerned, 3 or 4 cases which are concerned in 24, one has been settled in Lok Adalat because it is not a crime for which preventive detention can be invoked. Second is a crime wherein, Your Lordship, what they have done is that they have let me out on station bail. That is, they feel that there.
Last case was 2 years old.
Out of the 12, the last case was 167 days old from the date of the detention order.
The 10th case was 2 years back.
Yes, Your Lordship. Your Lordship,
One you were released on station bail.
Yes. Your Lordship, to briefly put.
That makes 12. You know.
And I was acquitted in one case. I was honorably acquitted in one case as well.
The other 8 or 9 are pending.
Other 8 or 9 are pending. They are pending trial. I've been enlarged on bail in almost all the cases. In one, I have not even been arrested.
Why so many?
Your Lordship, I do not know how to answer.
We are not putting it to you so that we can have answers.
Yes.
No, is it not? Not say so. Not unusual to have 12 cases.
Unusual, Your Lordship, but one more thing that I want to place for your consideration is that all these crimes almost flow from the same police stations. They say there are about 5 jurisdictions, but it seems like some sort of malafide action is being taken by one. Your Lordship,
Did you plead this malafide in any of those cases while making?
I have not taken that prayer, Your Lordship. But the other 2 points that I want to put for Your Lordship's consideration, apart from live and proximate link, is the second ground that I'm urging before Your Lordships is that when the detention order was passed, I was at liberty. I was granted bail in almost all cases. In one, there is an NBW issued, and in another, I was not even arrested. Now, those bail orders in which I have been enlarged at liberty were not even considered by the detaining authority. I've prepared a small synopsis for Your Lordship's consideration to show that wrong bail orders have been referred to and relevant material is not considered. Your Lordships, the allegations range from attempt to murder, assault, rioting, and all these sort of offences have been alleged against me, Your Lordship. Your Lordship, to my mind, about 2 cases. Your Lordship, no arms, ammunition were used, merely hands or some sort of, or machete or some swords, and all of those weapons have alleged to be used. The allegation is that, Your Lordship, the fact of the matter is in almost all the cases, the learned trial judges have considered my bail applications and enlarged me on bail.
Yes, my lord.
Weapons have been confiscated. That I'll ascertain, Your Lordship.
You have to see the totality. You put yourself in the place of the authority and then think forward.
May I just point out one last thing, Your Lordship? I understand it cannot be taken up today, but one last thing. Time and again, this honorable court has laid down guidelines.
We have given 2 or 3 judges.
Very well, you. Very well.
We'll have it tomorrow.
Very well, Your Lordship.
My lord, this matter requires consideration, my lord.
I'll take
I have
only
this
10
matter
minutes,
after
sir.
vacations, my lord, because even
Your
I had to.
Lordship,
Please, my lord.
When did you file this petition?
on 24th of March.
When did you delay it?
I did not, Your Lordship, he went through the hoops of going to the advisory board. He exhausted his remedies there. Yes. On
Advisory board has.
Advisory board has confirmed it. I'd even submitted a representation to the state government. So I was exhausting my remedies there. My detention order was passed on 29th of January. Immediately thereafter, Your Lordship, I'm before the court.
We'll have it tomorrow.
Very well.
Please.
Okay?
Very great.
But we will not give you much time. Let's be clear. We'll get your submissions.
Your Lordship, I have my synopsis ready. I passed it on.
Already you will also get.
Please, my lord.
Whatever judgments or anything, you have filed your counter, no?
Yes, my lord, I have submitted. Yes, I have submitted.
Counter is your submissions.
Yes, my lord.
Your Lordship, to assist the court, I've already prepared a synopsis. I'll just take 10 minutes. Very well. Just 10 minutes I'll require of Your Lordship's time. I'll take. Very well.
I may be permitted to file my synopsis along with statement. Please.
Yes.
Great.
Here number 6. Samartha.
Responding in this matter, my lord. And they have not been appearing. Even in the previous day, they did not appear. And the compliance has come for 7th time.
Was there any present last time?
No, my lord.
Why there no presence for the appellants? From the second call.
Twenty-five three. 25-3.
the last date of it.
Yes, ma'am.
We have just the appeal is dismissed for prosecution and in default. Yes. Which is your number?
For responding, appellant deposited the amount. I have filed the case in OS Commercial Court, and he was received the amount with the interest 50% already given, and 50% deposited through the High Court order in Nationalized Bank has to be released, and case may be disposed. No problem. Only the amount has to be deposited.
Have you filed any application?
Filed application one for vacate the release the amount.
Where is that?
I
The balance 50%.
1/24.
When was that 50% allowed? When did he file that application? Just asking. When did you file that application?
1/24, my lord.
So that has been answered.
Petition filed. 1 year
That has been
ago.
answered. 50% has been released after that. Ask him to file a fresh application.
This application, objection raised.
He hasn't filed any application.
Ask him to file a fresh application. Okay? Just tell him.
You are all, I have submitted in objection to the appeal. Amount 50% remaining to be released.
We will do it. File an application. Yes.
That's serial number 38. I apologize, my lords. The interim order has already been extended to disposal of the suit, my lords. The disposal by way of order dated 14/10/2022.
For 7, sir. 7.
My lord, I appear for appellant, my lord. I appear for appellant, serial number 7, my lord.
Yes.
I appear for appellant, my lord. SL has passed an award considering an extent of, can I continue, my lord? SL has passed an award considering 9 cent as 9 cent of land as non-agriculture land, my lord. An amount of 1,581 rupees per cent, my lord, in which land loser has approached honorable arbitrator challenging the SLO award, my lord. While enhancing honorable arbitrator, while enhancing the compensation, they have divided 9 cent as 5 cent out of 9 cent. They have divided 5 cent as non-agriculture, other 4 cent as wetland, my lord. And while SLO wrongly considered the entire SLO wrongly considered entire 9 cent of land and paid compensation to land loser, my lord. My lord, excess amount has been paid, my lord. My lord, SLO has paid excess amount to the land loser, my lord, to be recovered, my lord. My lord, on 27/3/2024, this honorable court has passed an interim order of stay, subject to condition 50% amount to be deposited, my lord. Already we have paid excess amount, my lord, to be recovered, my lord. This is my kind submission, my lord.
Just say that the counsel for the appellant state that the 50% of the officer has already excess amount has been paid to the respondent number 1.
Please, my lord.
That's right?
Yes, my lord.
Is the submission?
Please, my lord.
Be notified.
Grateful, my lord.
Lord, I'm serial number 40.
7.
Serial number 40. I'm a petitioner. I'm the petitioner. Today, my counsel has appeared in BC video conference. The new counsel has been engaged by the free legal aid, my lord. My lord, this case is required to be heard urgently for the reason I have been dismissed in 2018.
I have not yet challenged my dismissal order. I'm relying upon the outcome of this, on this. My lord, my entire institute is under a scam, big scam. It has led to 2,000 crore scam based on the entire service law, service rules and laws itself is not framed as per government rules and regulations. I have been wrongly dismissed for the charge that I have not completed the work order given by my superior. Only based on that order, I have been dismissed from the service itself without inquiry report itself. My lord, they claim that I have been regularly filing cases in court and not performing duties. That is the charge. My lord, this rules itself, when there is no rules from 1972, how can I discharge my duty, my lord? My entire work equipments, which are to be required for mandatory purpose of my work, that has been seized. After seizing, Lord, very long date, my lord. Very long date, my lord. Other side is the Indian Institute of Astrophysics. Councils were present today from the morning, my lord. Legal aid, my lord. I don't have funds to engage a private counsel. Some urgent date and 2:30. They are not aware of the date at all, my lord. That will be cause listed, even if they are councils, they will be cause listed, my lord.
Someone was there, we have been told.
He was asking me actually, my lord. Date he was asking me. No, I did not say. I didn't know the date at all.
If you want to have an early hearing, you file an application for early hearing. Tell your counsel. Okay?
14 and 17. 14 and 15, sir.
Serial number, Your Lordship, it was passed over to show the proof of paying the court fees, Your Lordship. I have done it. Your Lordship, in the last date, if Your Lordship recalls, Your Lordship had stated if I make good of the payment, notices shall be dispensed in this matter, Your Lordship. The reason is I am not asking for a stay of proceedings. I think herein I have asked for an alt.
We'll have it immediately. Let's look into this.
If it could be on Friday, Your Lordship. The reason is, Your Lordship, I was evicted on the ground saying that the property has to be sufficiated to the landlord's son. That was a wrong representation. Then they have put someone else in business. It was passed over to show the acknowledgement for being paid the court fee, Your Lordship. Maybe if it could be on Friday, I would take a chance. Please, Your Lordship. Much obliged, Your Lordship.
15, 2-6, sir. 15.
Much obliged, Your Lordship.
CST, on payment of 2-6 actually. Serial number 15, 2-6.
Serial number 38.
ಅಲ್ಲ ನಾನು ಬರ್ಕೊಂಡಿದ್ದೀನಿ ರಿಪೀಟ್ ಕೊಟ್ಕೊಳ್ತೀನಿ